my lord.
Yes.
My lord, the matter has become infructuous, my lord. It can be disposed of, my lord, as infructuous, my lord.
Anyone for the other?
My lord, on the last occasion, nobody appeared, my lord. 17-5, your lordship.
We each the learned counsel for the petitioner. Establish that there is no life for the vaccine and the matter has become infructuous. Matter. The petition is accordingly dismissed as infructuous. It's a new matter.
My lord, the matter relates to removal of precedent, my lord.
Okay.
May please, your lordship. My lord, I beg to mention item number 5, my lord.
Yes.
Can we pass off for a day, my lord?
The Gupta is not well.
Gupta is there. We could not prepare it yesterday, my lord. Some difficulty, my lord.
On the prayer made on behalf of the petitioner, matter is passed over to be listed next week.
My lord. Oblige, your
Item
lordship.
number 5.
Oblige, your lordship.
Yes.
May I please, your lordship, in item number 41 in order, I have filed one IA, lordship. In that, one typographical mistake occurred, lordship. May I be allowed to do that?
What kind of typographical mistake?
Means without pending one word unnecessarily, so I may be allowed to omit that word.
Where? In the pleading?
No, in the IA.
Leadings.
Yes, lordship.
We have to check then. Nowadays, the correction is not.
Because the
Allowed.
meaning of the sentence will not come out if I
We
do.
will see when the matter comes up.
May I please, lordship? I beg to mention item number 52, lordship. Lordship, it is an IA of the supply list.
Yes.
It is an IA for reviewing the order passed by court number 14, lordship. So matter has come up here. So whether if this honorable court
Is it
takes up the matter,
is it a review application?
review application, lordship.
No. But it has been registered as IA, not as review.
Lordship, that matter which was wrongly posted on a prior one day of the date of listing. That is,
IA to know.
the order which we have approached for review is passed by.
No, that we have understood. But is it a review or review of the order? If you're correct,
Lordship, actually, date is fixed day after tomorrow in the lower court.
it's a review please you wanna tell us.
So today itself or tomorrow, lordship, reverted to the appropriate.
Review of the order, review please. Review nomenclature sheet. Not a review nomenclature reviewed. IA to only the hand. The council, though you have filed as a review, there it is not in the format, there is no certificate, there are no grounds.
Lordship, I was asked to do an IA, to file an IA. So
No, you have stated in the cost title that's the review application, but review application cannot be filed in the manner in which you have done. There has to be a certificate, there has to be grounds of review, those are not there. Okay, it will go before the same court. What is your name?
yes, sir, my lordship.
Priya Sharma, learned counsel, submit that the present application is for review of an order passed by Honorable Justice
PGSIK, 14, court number 14.
PGSIK, for some registry to list this case for the appropriate bench.
Lordship, date tomorrow, day after tomorrow fixed in the lower court, lordship.
As urgency has been expressed, comma,
Today, if possible, or tomorrow.
Sri Sharma expresses an urgency as the case before the learned lower court is
Fixed on 11th.
said to be fixed tomorrow.
11th. Fixed on 11th.
It's on 11th.
In the lower
After
court.
tomorrow.
ESI tribunal.
Okay. Then registry may accordingly leave this matter before the appropriate bench tomorrow.
Lordship, deeply obliged.
My lord, I move in an urgent application on Monday, my lord.
Monday.
Monday.
You fresh matter,
Yes, matter.
which with this bench,
This one.
CRP.
Chair given.
Urgent why Monday, Friday,
Yes, Friday. Maybe.
or today?
Friday, my lord.
Yes.
I'd like to mention for listing, my lord, one MSc matter, my lord.
You are for the claimant.
Yes, my lord, claimants.
Why do you want listing?
My lord,
Why do you want the listing?
my lord, last posting, my lord, 23/1/2023, my lord. 2018 matter, my lord.
Now, what is the stage of the matter?
My lord, a respondent, my lord, already appear inter-appearance, my lord, by filing.
So need to be speak for hearing.
Yes, my lord. After 15 August, my lord, any day, 17.
I beg to mention the IO for listing, my lord, on 21, my lord.
I for
IA for, my lord, impeachment was rejected, my lord. Against that order, my lord, we have filed this IA, my lord. And my lord, the proceeding.
I for rejection of impeachment.
CRP IA, my lord. IO, my lord. So my lord,
What is the stage of the CRP?
my lord is orders, my lord. It has, other side has not yet appeared, my lord.
When do you want?
On 21, my lord.
May I please your lordship? Lordship, it's a MAC appeal, lordship. I beg to mention for listing, lordship. It's a MAC appeal. Notice was already issued,
What
lordship.
is the MAC appeal?
MSCT case, lordship.
Don't say MAC appeal. Say motor accident claim.
Motor
tribunal appeal. Nothing called MAC appeal or something. Yes, what is it? What is the stage?
It's a admission stage, lordship. Kindly matter will be listed on next week, lordship.
You are for the insurance company.
It is,
What is the stage of the case? Admission stage.
yes, lordship. Notice was already issued, lordship.
Other side has appeared.
Yes, lord.
I'll have it next week.
May I please,
Give
Lordship?
a date in the next week.
May I please, Lordship? I beg to mention for listing one MSc appeal, Lordship. It was listed on earlier May to 10 May.
Your appeal is by the whom? Preferred by-
Appellant by the state fire and emergency service, Lordship.
What is the stage?
It was listed on motion column, Lordship. Unfortunately, we have missed the case, Lordship.
Okay, it is at the stage, first stage itself.
Lordship,
Initial stage.
initially.
Okay. When do you want? Monday?
16 of
Monday?
okay, Lordship. March of last year.
May it please your lordship, lordship, I am paying for listing of one MSc appeal, lordship. Matter was last posted on 28/2/2023 and it was fixed on 23/3/2023, but it was not listed. Lordship, kindly can
Not listed or not reached?
not listed, lordship.
How is it possible? If there's a court order, it has to be listed. Okay, when do you want?
On any date in the next week, lordship.
Okay, next Friday.
March
Not
of
this Friday, next week.
Right.
Not this Friday, next week Friday.
next week. March of
May I please, your lordship, lordship, I beg to mention you for the listing of a matrimonial appeal.
New method.
No, it's pending for admission, but not listed for a long time.
Case of which year?
2022.
Okay, next week, you were Wednesday. Next Wednesday.
No, okay.
May I please, sir? Sir, I am wife, lordship, petitioner with lordship. My husband filed a matrimonial suit before the district judge, Hojai, lordship. So I am having no income, lordship, and my fathers are old. Para 6 pace, para 10, I will explain my problem, lordship. The distance of Bongaigaon to Hojai is about 340 kilometers. And it takes 10 to 12 hours, lordship. And I am not economically sound. And there is no male member in family, lordship. So I need that this matrimonial suit may be transferred from Hojai to Bongaigaon so that I can contest the case later.
The suit is for divorce.
Pardon, sir?
Suit is for divorce.
No, matrimonial, he got restriction of conjugal rights.
You want restoration of
Conjugal
conjugal rights.
rights, yes. Husband is sitting, lordship.
Why have you come from Hojai to Bongaigaon?
Lordship, I am in Bongaigaon.
Why have you come?
To transfer the suit from Hojai to Bongaigaon.
Why have you left your matrimonial home at
Yes,
Hojai?
some dispute with my husband, lordship, they are claiming something, their mental torture is there. This is the reason, Lordship. So a compelling circumstances are
When was
actually
the marriage?
marriage Lordship to 21, Lordship.
Any issue? Any
No,
issue?
no issue, Lordship.
Let us see the application for restoration of conjugal rights,
Yes, page 13, Lordship.
1-3.
1-3, Lordship. Next, 1, Lordship. 5 and 6, they have explained their problem, Lordship. In 4, they are saying that we are living together at the matrimonial within a month. The respondent started mental cruelty to the petitioner. They are saying that I have started, but think is not correct, Lordship.
You have also attempted suicide.
But no, sir, it is their statement, Lordship. But I am not in that.
Have you filed your written statement?
Yes, Lordship. On past occasion, I have filed and denying their.
You have already appeared.
Yeah, that was the first day, Lordship.
Where is your written statement?
Written statement, Lordship, not I have got, Lordship.
You have already submitted your steps to the jurisdiction of the Ojai court.
Yes, sir.
Now, why transfer?
Only first day only I appear and file the written statement stating denial of staying there, Lordship. That is the thing.
If you
And-
can go there, file written statement,
Yes, sir.
what is the problem?
Only 1 day, Lordship, from Bongaigat Hojai, but it will be too difficult for me, Lordship. I am none in my family, Lordship. Only old parents are there.
You stay in
Yes.
your husband's place. Where are you conflicting? It's not a case for divorce.
Yes.
You have to resist. He is wanting you back in the matrimonial house.
But it is difficult, Lordship. But think is that if something is done, that can be in Bongaigat also no. But for me, at
No,
this stage,
See, it's not a case for divorce. Neither we have
Yes.
approached for divorce.
yes, Lordship.
Have you resisted the application for restitution?
Yes, Lordship. He filed. My
Have
husband,
you resisted it?
no, Lordship.
In your written statement, have you denied?
Yes, Lordship.
You don't want to go back to your
No,
husband's
Lordship.
house. Distance alone may not be the sole factor. Hard 3D date to account for the petitioner who by means of this petition filed under section 24 of the CP has paid for transfer of matrimonial case number 2 from the court of the district judge Ojai to the court of the district judge Bongaigaon, Landlord-tenant law. This suit has been instituted by the opposite party husband under section 10.
Yes, Lordship.
This is restitution.
We are seeing judicial separation, Lordship. Section 10, they are saying judicial separation.
Then you say restitution.
No, Lordship, mistakes, judicial separation.
What is this? We proceeded with the premises that it is a petition for restitution.
No, Lordship, judicial separation. Section 10, judicial separation. This is my mistake, Lordship.
You are not even briefed with the fact of the case. What is this kind of submission? Right. Come prepared. Don't make this kind of submission. Making basic fallacy in the fact. A petition for
That's it,
judicial separation, you are terming the petition for restitution of conjugal right. What is this presentation?
No, Lordship.
Is this any assistance to the court?
No, Lordship. Lordship,
Monday
may I allow to withdraw the petition?
Sorry, Monday.
Lordship, may I pay to withdraw the petition? Lordship?
Friday night. Day after tomorrow.
Lordship, can it be put tomorrow?
Day after tomorrow, Friday.
May it please, Manoj?
Yes.
Manoj, the petitioners, Manoj, are assailing the order dated 17 June 2023, Manoj, passed by the learned District Judge Kamrup Metro, Manoj, in an application under Section 29A of the Arbitration Act, Manoj, seeking extension of the mandate, Manoj. Primary grievances, my lords, there were 7 arbitration proceedings that were initiated between the parties, my lord, between
Let
the,
us come to the impugned order.
my lords. The impugned order starts at page 450, my lords.
450,
50, my lords. If I can just place the facts, my lord, that they'll be probably relevant, my lords.
Who are you?
My lords, I'm the respondent, my lord, the opposite party in this application, and the
No.
respondent in the arbitration proceedings.
You are the respondent in the
Arbitration proceeding as well as the respondent in this application, my lords. The application before the learned
Understood.
district judgment.
Claim is for what?
My lords, claims, there are, my lords, if I can just place the facts, my lords, the Oil India Limited had floated a tender, my lords, for procurement of oil and gas separators, my lords. The respondent had emerged as the L1 bidder, my lords. Accordingly, 7 purchase orders were issued to the respondent, my lords. My lords, disputes arising out of seven of those purchase orders, my lords, culminated into 7 arbitration proceedings in total, my lord. My lords, may kindly have page 105. An arbitrator was appointed, my lords. And this is the first
7 arbitration.
7 arbitration
7
proceedings,
dispute.
7 disputes, my lord. Page 105, my lords, is relevant.
105.
5, my lord.
Okay.
This is the first order that was passed by the learned sole arbitrator, my lord. (106) is relevant, my lord, bottom of 106. Having considered the facts so far revealed and the
This
submission,
order was passed where? In which petition?
my lords, there were 7 separate arbitration proceedings were registered. Subsequently, thereafter, my lords, there were separate orders were passed for all those proceedings, my lords. Now,
And this order pertains to what is the context of this order?
my lords, what I wanted to show is there were 7 separate proceedings that were initiated, my lords. Now, what had happened is, my lords, the proceedings, my lords are aware under 29A, after completion of pleadings, the award has to be passed within a period of 12 months. If that is not done, my lords, the parties can consent to an extension, which is maximum for a period of 6 months thereafter. Now, in this case here, what had happened is that 18-month period had expired. So the extension of the mandate can only be done on an application being filed before the court, my lords. And in our case, my lords, and when it comes to Guwahati, my lords, since the Honorable High Court does not exercise original jurisdiction, principal civil judge, court, my lords, I'm so obliged. So the application that was filed was for only one of those arbitration proceedings. Now the learned district judge, what he has done, my lords, our primary ground for, my lords, this petition is that in that very application, the extension was granted for 7 of those proceedings.
All
When
the other 6 also.
all the other 6 also, my lord. Secondly, my lords, the relevant provision, my lords, may kindly have 29A. Section 29A, my lord, subsection 5. May I read this, my lord? The extension of period referred to in subsection 4,
You are reading?
section 29A, subsection 5, my lords.
By the amendment of 16. Amendment of 2016.
My lords.
Yes.
The extension, I'm reading subsection 5, my lord.
Yes.
The extension of period referred to in subsection 4 may be on the application of any of the parties and may be granted only for sufficient cause and on such terms and conditions as may be imposed by the court. Malas, there is absolutely no deliberation, no reflection of any cause being shown. Those were we filed our objections. Malas, we said that this application cannot be sustained. There have to be 7 separate proceedings. What the learned district judge did, Malas, if Malas kindly has
It could be sustained for so far as that is.
only for one of those matters.
You cannot say that it will not be sustainable for all.
All.
You
Yes,
may
Malas.
have an objection regarding that petition also if they have not shown sufficient reason.
Malas.
That is another
That is another.
segment of your argument. And the other is that this one common application cannot be.
For all of the 7 proceedings.
And what was the reaction of the honorable court?
Well, what the learned district judge, my lords, observed
405,
450, my lords.
450.
No, relevant, my lords. 458 is relevant, my lord. For the objections raised by the respondents before the learned district judge, my lords. Bottom of page 458.
It starts at 450.
Yes, it starts at 450. my lord.
What is the date of the order?
17 June 2023. I'm reading, my lord. Bottom of page 458.
458.
My lords. The reasons assigned for granting of extension in the 7 proceedings, my lord. The last paragraph at page 458, my lord. Now coming to the prayer of the petitioner for extension of the period of the arbitral tribunal, it is found that the objections of the respondents are twofold. Respondent has prayed for rejecting the prayer of the petitioner for extending the period of arbitral tribunal. Further objection of the respondent is that it has filed objections strictly in regard to arbitral reference case number so and so and so and so, and not against 5 other reference cases, since prayer has been made by the petitioner with regard to 2 numbering arbitral references. Now, the application is filed for 2. So the reason assigned by the learned district judge is given thereafter, my lords. In this connection, the petitioner, by filing counter reply against the objection, has stated that the application has been filed seeking extension.
Where are you reading? Page?
459, my lords. In this connection, my lords, the top of page 459. In this connection, the petitioner, by filing counter reply against the objection, has stated that the application has been filed seeking extension period of the arbitral tribunal with regard to all the 7 reference cases. It has been further stated in the counter reply that the arbitral tribunal has taken up all 7 reference cases together for a decision passing a common order, which is completely not true, my lords. Now, thereafter, my lords, the learned district judge observes, I have perused the record. In the cause title, the petitioner has mentioned, as stated herein under, for extension of so-and-so in reference case number PCB so-and-so 13 and 14 of 2016. And in the matter of, he refers to all the 7 proceedings. From the cause title extracted above, it is found that the petitioner had mentioned all the 7 numbers of reference cases. Learned arbitral tribunal has also passed a common order in reference of all 7 numbers of cases. Therefore, it does not appear that the petitioner would make prayer for extension of arbitral tribunal only in respect of 2 reference cases. Respondents does not dispute the facts of coincidence. Number only relying on the cause title, my lord.
See, the role of a court is minimal in arbitration proceedings. Now, this procedure is adopted by one of the parties seeking time by taking the benefit of 29A5. Should we interfere at this stage? What prejudice are we suffering?
Malaj, we are a PSU, Malaj. We are leaking money because of these proceedings. Now, we had submitted to the arbitration proceedings. We had been diligent all throughout. Because of their lack of intent, Malaj, if I may say so. What they did, they sought time again and again, Malaj. The proceedings could not be culminated. Otherwise, the proceedings were simple, Malaj. Now, what has happened, Malaj, the act principally states, my lords, the section that cause has to be shown. Now, there is no deliberation as to whether cause has been shown. And as far as Article 227 is concerned, my lords, the non-obstant clause of Section 5 will not come in the way. On this issue, my lords, I'll place reference to a reliance on a judgment, my lord, of the Supreme Court.
Ultimately, it's a revision jurisdiction.
That was para 17, my lord, for a moment. My lord, this is a judgment rendered by a 3 judges bench of the Honorable Supreme Court.
1-7.
1-7, my lords. This being the case,
When
there
is
is
the
no,
next date?
my lords,
When is the next date?
my lords, the mandate has been fixed. The mandate has been extended by another 6 months. The date has not been fixed. So I am not sure whether the arbitrator has received notice of the order.
This order is a 17-6, but
17-6, but we have not received instructions yet, my lord, from the arbitrator. Whether or not the petitioners have gone ahead and informed the learned arbitrator, we are not even
definitely
aware.
they will inform. It. Paragraph 17.
17, my lord. This being the case, there is no doubt whatsoever if the petitioners were to be filed with so-and-so against order passed in so-and-so, the entire arbitration,
Yes, just read it. It's being-
para 17, my lord.
Yes.
The second sentence here is
No, no,
important.
read the interesting.
My lords, I will. This being the case, there is no doubt whatsoever that if petitions were to be filed under Article 226, 227 of the Constitution against order passed in appeals under 37, the entire arbitral process would be derailed and would not come to fruition. At the same time, we cannot forget that Article 227 is a constitutional provision which remains untouched by the non-obstant clause of Section 5 of the Arbitration Act. In these circumstances, what is important to note is that though petitions can be filed under 227 against the judgment allowing or dismissing first appeals under 37, yet the High Court would be extremely circumspect. Now,
Yeah.
there is a my lords, another reason assigned, my lord, when it can be done, my lords. Last line, my lords, of the Act, yet the High Court would be extremely circumspect with the same, taking into account the statutory policy as adumbrated by us herein above, so that the interference is restricted to orders that are passed, which are patently lacking in inherent jurisdiction, my lord. That is our case, my lords. Well, the learned district judge could not have passed that order, my lord, because he did not have the inherent jurisdiction to pass an order extending the mandate in 7 proceedings.
The proceedings were held together, isn't it? Analogous.
Held together. But there were separate claims, there were separate statement of claims, separate defenses. In some of them, there were counterclaims also, my lord.
Now, issuing notice and giving this matter pending will be against the entire objective of the enactment. The proceedings will be unnecessarily delayed. We are not too inclined to accept your submission. 17 is we are following 17. We will not say that 227 is not maintainable. It's maintainable, but to exercise powers, we need to have something else.
Now, the Act itself, the provisions of the Act have been violated, my lords. The order otherwise, my lords, respectfully cannot be sustained. Was that order?
We may not be that technical. You may be correct in contending that if you see technically, this were for 2 proceedings. Order has been passed in 7, but he has given reasons. All the 7 proceedings mentioned. And what is the prejudice you are suffering after?
Well, we are facing the brunt of an arbitration proceedings, which they are not even serious to continue with. What they did,
It's a right given by an act. They have.
Well, I bow down to that.
Jurisdiction. You have not said that arbitration is not maintainable.
I'm not.
There is a dispute.
Well, what they did initially,
It may be it is likely that the award may not be in their favor. It may be dismissed. Cost may be imposed. But can you just fulfill the right
Well, the right
at the beginning, at the threshold?
well, that at least, my lord, the matter may be remanded back. There has to be appreciation of these facts, my lord, because the
Demanding back. We'll issue who's for the other side.
there is no one, my lord. There's private respondent, my lord.
Notices have been issued.
No, my
earlier.
lord, no notice hasn't been
Parties from where?
from Maharashtra, my lord.
You have the council appearing. Who's there are council appearing in the arbitration proceedings?
There was, my lord. I do not have contact with them any further, but I can inform them.
Local council.
There is a local council, yes.
Please inform him we are issuing a short notice. We'll try to dispose of this matter.
My
Within
lord.
2 weeks.
My lords, if I may also show another thing, my lords, another application, similar application under 29A at page 444, my lords.
Yes, what has happened there?
That very same application before the learned district judge, page 448 and 449 are important, my lords.
What is happened?
What these applications were dismissed because no cause for expansion or the extension of the mandate was shown, my lord. Similarly, my lords, they are similarly placed. Or there is absolutely no deliberation.
Under
We-
whom? Where those, same dispute?
Not same dispute, my lords. At least Oil India was a party to that dispute.
Maybe. That is page 440.
448, my lords, is relevant. It starts at page 444.
Same party.
Oil India is a party. The other respondent is not a party.
The reasons are apparent at 449.
Yes, my lords, because he has failed to show any.
Learned arbitrator has given an indication that he will be out of station, so you file an application. But the application was filed after a significant delay, and that delay has not been explained.
Yes, my lord.
That
Even
was the
in this case, what had happened, the mandate expired on 14th March 2018. What the respondents did, my lords, respondents, instead of filing an application for extension of the mandate before the learned principal civil judge,
They came before this court.
they filed in section 11,
Yes,
which was
yes.
dismissed.
Mm.
But thereafter, after an inordinate delay of almost close to 90 days, they filed the application.
But there are observations of this court.
There were observation. My lord, there was also a direction.
We cannot equate with this case.
My lords,
There is an observation.
my lords, there is an observation. As I'm not disputing that. But there was also a direction to dispose of the application as early as possible, my lord. The section 29A also says an application under 29A5 has to be disposed within a period of 60 days. And that has also not been done.
We beach already learned counsel for the petitioner who has filed this petition under Article 227 of the Constitution of India, being aggrieved by an order dated 17/6/2023 passed by the learned district judge Kamrup in Miss R number 30 of 2019. Full stop. Para. In brief, the projected case of the petitioner, Mrs. Oil India Limited, is that in the course of 7 numbers of tenders, 7 number of jobs,
Purchase orders. my lord.
7 number of purchase orders, which were allotted by tenders, 7 disputes have arisen. And in view of the existence of an arbitration clause, 7 arbitration proceedings were initiated. Full stop. However, since the time frame by the Arbitration and Conciliation Act 1996, which is of 18 months after extension,
After extension.
was coming to an end, the claimant who is common in all these 7 disputes had filed the aforesaid application before the learned district judge Kamrup by invoking the provisions of section 29A of the Act. By the impugned order, the state application has been allowed. Assailing the state order dated 17/6/2023, it is submitted that the application that even assuming that has submitted that firstly, the application is to be disposed of only when sufficient cause is espoused. And in this case, it is submitted that the state obligation was not discharged. Secondly, it is submitted that even assuming that the ingredients of the section are fulfilled, comma, one application for 7 disputes, 7 arbitration proceedings cannot submitted that one order which has been filed, which has been passed in one of the arbitration proceedings cannot cover cannot cover all the 7 disputes, and therefore the order is not sustainable. The arbitration proceeding, it appears is of the year 2000 and when
16, my lords.
16, and the work orders itself are of the year 2008 or where?
8 onwards, my lords.
No, 5 onwards. 5 onwards. 2005 onwards.
5 onwards. I'm sorry.
It is between 2005 to 2008. Okay. This court issue notice returnable on on 30th of August. That step be taken for service of notice upon the sole respondent be taken by registered post with AT as well as by state post. Steps within 2 days. Considering that the present case relates to an arbitration proceeding which is required to be completed expeditiously, comma. This court has also permitted Sri Chaudhary, the learned counsel, to serve notice of this case upon the learned counsel who represent the claimant in the arbitration proceeding for the learned arbitrator. Sri Chaudhary prays for an interim order. Though this court is not inclined to pass an interim order at this stage, a blanket interim order at this stage, comma, balancing the equity and in the interest of justice, it is provided that till the next returnable case, comma, the further proceeding in the don't say further proceeding. The operation of the impute order dated shall remain suspended. The interim direction, however, will be reconsidered on appearance of the parties, and an endeavor will be made to dispose of the entire matter.
I'm deeply obliged, my lords.
May it please your lordship. Mother, we are faced with a difficulty with the interplay of section 13B of the Hindu Marriage Act, as also the Guwahati High Court mediation rules. This is so inasmuch as I am, being the husband, had filed an application for restitution of conjugal rights. My wife came to the Honorable Court in a transfer petition seeking transfer of the petition to North Lakhimpur.
From
Guwahati,
From what?
family court Guwahati to North Lakhimpur. In this honorable court, we opted to go for mediation. There was a mediation at the Guwahati High Court Mediation Center. Eventually, a report was filed. Added in, we came that I'll pay 5 lakhs to you, 2 lakhs on the first day, 3 lakhs on the next day. Whatever gold jewelry, etc., we done, and they agreed to go for divorce. Accordingly, this honorable court closed that transfer petition on withdrawal. And we to go there. We went there and filed an application under 13B for joint application for mutual divorce. However, before that date, I had paid 5 lakhs, acknowledged and admitted by the wife in the joint petition. No, we are not difficulty on that. But the learned family court,
Lakhimpur.
family court,
Lakhimpur.
Kamrul Metro, had posted the matter again and again on several dates, initially for conciliation, then for other orders, and every date I am to pay 4,000 to my wife. I had agreed initially in the mediation that all right, there will be
Where
natural.
is that order of Justice, Honorable Justice Goel? I think that 6 months period can also be.
Absolute, that is not there with me, Vinod.
Why?
I did not, I understand.
But if you understood, you bring that. on
6 months
Friday-
would go, man.
On Friday, we'll dispose of.
Friday I would not be there, Vinod.
Monday is the holiday over.
Monday, no, 14 is there.
14.
I know,
There's an order.
I understand.
And under.
In fact, I would be referring to that order
This
that did not have in the
circumstance,
hand.
mediation has already
Done by.
done, and this court has passed an order. The question
So the
of
6 month period goes away. Very good. 14th, Vinod,
Yes.
for motion.
on
Obliged.
the prayer of the telephonic response for the petitioner is for motion on 14th.
Grateful, Vinod. Obliged.
Wait, please, your lordship. This revision petition has been filed against the order passed by the learned first appellate court, whereby my petition filed under order 39, rule 1 and 2, as I was refused by the earlier by the learned trial court, was no order was passed. In fact, a notice was issued, and the next date was fixed for filing objection and service report. My lord, there is a case, my lord, I being a plaintiff, filed a suit for specific performance of contract for an agreement of the year 1991.
Just a- You're the plaintiff.
Yes, please.
So for,
Specific performance of contract.
okay,
Their written statement has been filed by the different number 129.
okay.
But during pendency of the suit, my lord, the different number 129 allegedly sold some portion of the land to different number 12 and 13. And on the basis of that sale deed, they are now trying to dispossess me. So we filed a petition before the learned trial court for grant of an interim injunction or status quo to protect the suit land. But the learned trial court
You filed the order 39 application during the
pendency of the suit.
Because the development has taken place during
Yes,
the
my lord.
pendency.
Yes.
Okay.
But the learned trial code, if I may take your lordship to page 18.
Page 18, what has happened?
Well, while not considering the mandate of granting ad interim injunction when some specific case has been made out, simply issued a notice and kept for filing objection.
Trial court,
Yes, my lord.
dated,
Dated 5/7/2023.
trial court,
Yes, my lord. Learned Court of Civil Judge Sunitpur.
okay.
Being agreed to file an appeal before the learned court of district judge.
Okay. Okay, then,
However, the learned court also did the same thing by order date 15/7/2023 by referring to section 108 of the Code of Civil Procedure. Just issued notice and kept for service report and objection. Order is available at page 16, my lord.
Let us see your plain.
I'll plain your lordship will find at page 19.
Nine.
So I've been in possession of the suit land since the year 1975.
Where is it?
My lord, para 3. If I may read, my lord.
Let's see your where in the main.
Page 30, my lord.
Where is the prayer for permanent injunction?
Well, the development took place, my lord, after filing of the suit, my lord. But the sale deed was executed, but before that, my lord, there was no such development. So we did not file
Can
any.
you pray for injunction, temporary injunction when there is no prayer for permanent injunction?
But when the subsequent development has taken place, my lord, when the suit was pending for evidence, well, subsequent development has taken place. That's they have.
Let us see your case.
Page 48, my lord.
48. Yes. Where are the relevant?
Relevant paras, my lord. Page 18, my lord. Sorry, my lord. Page 60, paragraph 18.
60.
60.
Yes.
The different number 9 and 10 do not contesting the suit by filing written statement being get fuel from the different number defendant opposite party number 129 on 26/6/2023 accompanied by several unknown persons and with a hired tractor of one Mr. So-and-so, village so-and-so, wrongfully encroaching the suit land, intending to dispose the plaintiff petitioner. They are also carried arms with them to use force to take possession. The plaintiff petitioner is suffering serious infection on his leg for last several months and not been able to move. Therefore, his sons and other family members went to protect the lawful possession of the plaintiff petitioner, and for that, the defendant opposite party number 10 and 11, as well as their goons, tried to assault them. The plaintiff petitioner immediately informed circle officer and local police station. The circle officer and police, though, asked the defendant opposite party not to use force, but they clearly informed the plaintiff petitioner that they will not help any further, as it's a civil dispute. It was surprising that while the different opposite party number 10 and 11 were using force to take possession of the suit land, the different opposite party number 1 and 2 were also present with the said defendant opposite party, which is a clear indication that all the defendants are in conspiracy and came with common intention to take forceful possession of the suit land. The defendant opposite party number 1 to 9 is doing totally opposite of what they have stated in the suit by filing their written statement. Well, interestingly, when the defendant number 1 to 9 has filed a written statement.
What was the your main basis of filing the?
Well, my basis of filing of the
suit of specific for specific purpose of
it's the agreement entered into between the parties by which they agreed to sell a portion of the land. My lord, out of 8 acres of land, 3 acres they have already sold to me, and rest
the concluded contract.
Yes, my lord.
Where?
And admittedly, they have admitted in the written statement. If I may take your lordship, it is a very interesting point.
We do one thing. Okay. Oh. Cannot remand all. When is the next date in the appellate court?
My lord, 22 September 2023.
Three. As this was when it counted for the petition. who by means of this petition filed under section, filed under Article 227 of the Constitution of India has put to challenge an order dated 15/7/2023 passed by the learned additional district judge, Punit in Mistake case number 43 of and in Mistake case number
Miss appeal number 4 of 23.
Is appeal number 4 of 2023 arising out of Mistake case number 43 of 2023 in title suit number 57 of 2020 before learned court of the civil judge. Punit. The petitioner is the plaintiff and the suit was instituted for specific performance of contract. It submitted that though there was no specific prayer for permanent injunction, during the pendency of the suit, there were attempts to dispossess the petitioner plaintiff from the land which he claims to be in possession since the year 1975. And therefore, the aforesaid case under Order 39, Rule 1 and 2 of the CP was filed. There the learned trial court, however, had issued notice in the state application without passing any ad interim order, and the state order was the subject matter of challenge by the first by the petitioner in the first appellate court by preferring the aforesaid appeal. The learned additional district judge, Punit, by the order dated 15/7/2023 had issued notice and has fixed the next date for objection and service report. The learned counsel for the petition has submitted that until some ad interim protection is granted, the entire suit may be rendered infructuous, and the very object of filing application for injunction would be returned. There are issued notice returnable on. We'll have a date before next date.
Yes, ma'am.
On 1st of September. That step for service of notice upon the respondent be taken by registered post step by tomorrow. Where the learned counsel has paid for an interim order considering fact and considering the facts and circumstances and also taking into view that the prayer for injunction has not first been rejected. This court is of the view that some interim protection is required to be given to the petition. It is therefore direct that till the returnable date, You're praying for stay of the,
Well, we have filed a
Right.
separate IA injunction.
why are you praying for stay of the proceeding?
The stay is not necessary.
Stay of, obvious, of
Yes,
course not
not
necessary.
necessary.
Higher returnable offenses as within by tomorrow. Okay, but the previous the learned in an academic the previous the learned counsel for the petitioner pays for an interim order which is being considered in the connected I not hard prayers discussed learned counsel who has filed this application under order 39 road 1 and 2 seeking ad interim temporary injunction. Full stop. It is perfect. He can do any the connected civil revision petition number 250. No, don't write. This court has issued notice in the connected CR 250/2023 today, that is to after hearing the hearing the learned counsel for the petition and considering the facts and circumstances from this court is of the view that interest of justice would be served and the equities will be balanced if some ad interim protection is granted in favor of the petition till the returnable date. It is accordingly direct that till the returnable date, the opposite parties are restrained from enforcing upon the land of the petitioner and also directed not to change the nature and character of the suit and the the aforesaid order of an interim injunction could be reconsidered after appearance of the parties in this case. Same issue notice returnable on to Yep.
Much obliged.
Except in both the matters.
Yes, madam.
Injunction application, same day we cannot dispose of.
Yes.
Look, it's good. Yes.
May I please your lordship.
What is it?
My lord, I am the one of the decree holder, my lord. Along with the other 7 decree holders. A decree was in favor of the petitioner as well as in favor of the respondent number 1 to 7 for recovery of possession as
Just a minute. You are the plaintiff,
I
one of the plaintiffs,
one of the plaintiff.
petitioner. There were 7 plaintiffs.
There were altogether 8 plaintiffs.
Suit for
Suit for recovery, declaration of right title interest, recovery of possession, and cancellation of a deed.
recovery of position and
Cancellation of a deed.
what did?
One Ekran-nama was executed in with respect to
What number?
Ekran-nama. That means sell deed executed.
Deed for sale, deed of sale.
Yes.
Then suit was declared in your favor.
Decreed
in favor of me as well as in favor of respondent number 1 to 7.
Thank you.
And suit basically over a shop house, not a big plot of land. Then it carries up to the second appeal, then they have lost.
The respondent, the
Defendant. Then during pendency of the execution case.
Yes.
Execution petition filed during pendency of the execution case. The decree judgment letter handed over possession to me.
Yes.
Then I filed application before the executing court. That degree has been satisfied because I got the possession of the land.
Top house has been given to you.
Yes. But the executing court, without satisfying the decree executed, went for proceeding and attached the property. So property was attached under Order 21, Rule 58. I filed an application.
You filed.
I filed.
Yes.
I filed application that adjudicate the matter. What is my share? What is their share? Then execution be proceeded. But executing court kindly see, prior to that, I have approached before this honorable court twice. Kindly see page 90. 90. There is some interchange in page number 90. Kindly see. Mr. Ghosh, learned counsel on behalf of the petitioner submit that they may be given liberty to file fresh application in accordance with the provision of Order 21, Rule 58 of the court, on the basis of which petitioner claim adjudication of this right, title, and interest in respect of the property attached. He submits that in view of the observations so made in the impugned order, thereby directing the petitioner not to file any petition in future, the said liberty is required from this court. Having heard the learned counsel for the petitioner as well as the respondent, and upon perusal of the application so filed, which has been registered as petition number so and so, the court deem it proper to grant liberty to the petitioner to file appropriate application in terms of Order 21, Rule 58, seeking adjudication in terms of so and so. Then within 1 month, I filed application that page 10. Sorry, Annexer 10, page 92. Page 92. Lordship got. Page
94.
92.
92.
Yes, petition.
You're under 21 for 58.
Yes,
Your petition.
this is the petition.
You are Azir Uddin,
No, I am
Rabia.
Rabia.
Okay. And what if
Then on the basis of this petition, the order has been passed without adjudicating the Order 21, Rule 58.
where is the order?
Page 97.
97.
97. Heard learned counsel for the petition number so and so filed by Rabia Begum Lashkar, one of the decree holder under Order 21, Rule 58 CPC, whereby petitioner prays for vacating the order of attachment passed by the court on so and so, and
You
declared
were in
that
pollution with the judgment letter.
no, I got the possession.
You were in pollution.
But now this suit property is in my possession.
Why? There were 8 numbers of plaintiffs.
Yes.
Why was it given only to you?
Actually, in earlier suit also, when they have filed the suit, I was minor.
Now the others have been, 7 have been excluded. Only it's given to you. Okay, but your application is there for adjudication of the claim.
That was not decided.
Let us see.
So that was not decided whether what share is my share, what is their share.
Has this application been rejected?
Rejected.
Where?
In the kindly see one,
Does not seem to vacate the earlier order.
yes, only not decided,
Not decided.
not decided.
Okay, we'll request the court to decide the matter.
Yes.
That will serve your purpose.
Yes,
But
it has not decided, not touched at all.
that aspect of the
Of the
matter.
matter has not gone into.
Even if you do not vacate the interim order, you decide 2158.
Yes,
But we'll have to issue notice at this stage. Without hearing the other side will not be fair. Third, the SK goes on its counsel for the petition who has filed this petition under Article 227 of the Constitution of India, being aggrieved by an order dated. Where you so late? Order is of March,
March 23, yes.
thereafter some proceeding,
I filed application,
10/5 was the date.
yes, I filed application that we are approaching there.
This matter is not stated. Who has being aggrieved by an order dated 20/3/2023, passed by the learned Munsif number 1, Hailakan, in title execution number 7 of 2015. It is submitted that the petitioner is one of the 8 numbers of plaintiffs in title suit number
Title suit number 43 of 1990.
43 of 1990, which was filed for declaration of right, title, and interest and recovery of possession. The suit was decreed in favor of the plaintiff, and the same was affirmed by the appellate court, including this court in the second appeal, referred by the judgment letter. Thereafter, the decree was put to execution. In the course of such execution proceeding, the judgment letter had handed over the possession of the suit property, which was a shop house, to the petitioner. Accordingly,
On 10/8/2016.
on 10/8/2016, accordingly, the petitioner had filed an application to close the execution procedure. However, the learned executing court had attached the property, whereafter the petitioner had filed an application before this court under Article 227 of the Constitution of India, which was registered as CRP number 263 of 2019. The state CRP was, however, disposed of by giving liberty to the petitioner to approach the executing court by filing an application under Order 21, Rule 58 of the CP. Request the learned counsel for the petitioner submit that on that on 22, when was it? That in compliance with the order of this court, the application under order 21 rule 58 CP was filed. However, by the impugned order dated 2023, there was no consideration of the said application by the learned court below, and rather the learned court had made an observation that the earlier order of attachment was not liable to be vacated. It is submitted that the provision of law as laid down in order of 21 rule 58 is for adjudication of claims and objections to attachment of property. And it is submitted that the impugned order does not reflect that there were any discussion in that line. Where I used to notice that returnable on 1st of September 2023. That step for service of notice be taken upon the respondent by registered post within step within 2 days. We are not saying any proceeding.
Proceeding may be stayed, but
Why?
attachment may not be stayed. Proceeding,
Doesn't
Attach-
not make any.
no, otherwise, if possession is taken without deciding order 2158, I will be
Who-
prejudiced.
Who will take position?
The court directed to, decree holder are directed to take necessary steps immediately to expedite. That means read to execute the read.
At this stage, we don't think.
Only proceeding. Attachment I am not.
Those three ghosts has paid for an interim order. This court is of the opinion that presently no such direction is necessary. However, liberty is granted to approach this court if the occasion arises.
Well, Lord, regarding attachment, I have not praying, but
Let us,
if execution is carried out, everything
execution cannot be carried out.
that is
That
the
you come for this, there were, time has been granted. Let us-
consequence.
Yes.
My lord, here in the petition, my lord, the petitioner and respondents are tenant, my lord. Petitioners are tenant of the respondent. And the tenancies still exist, my lord. Now, what happens, my lord?
You are the tenant.
I am tenant, my lord. There are two petitioners, the petitioner 1 and 2. Petitioner 1 is the tenant, and the petitioner 2 is a attorney holder, my lord. So why he is attorney, my lord? Because up to 2000
Attorney of petitioner number 1.
petitioner number 1, my lord. So what happened, my lord? The tenancy expired on 2015.
Who is the landlord?
Landlord is the Mahabir, my lord.
Respondent.
No, Lokhi, my lord.
Landlord is the respondent.
Respondents, my lord. Lokhi and Apurva.
Landlord.
My lord.
So stood for ejectment.
Actually, now what happens, my lord? That matter is something different, my
Suit
lord.
was for.
My lord.
Suit was for.
Suit
Suit was
was-
for.
For I filed a suit and they also filed. They filed suit for ejectment,
And your suit.
and my suit is that I may be allowed to continue as a tenant, my lord. That is my suit, my lord.
Then?
My lord, what happened in the year 2015, my lord, the petitioner number one got cancer patient, but he became cancer patient, and therefore he entrusted his business to his nephew, that is petitioner number two, my lord. And he left to Rajasthan because of his treatment, my lord. And all the business is run by this petition number two. My lord, the tenancy in the year 2015, the tenancy expired, but still he is paying the rent to the respondent, my lord. Now what happens, my lord? Abruptly on 9/4/2023, the respondents locked the shop premises, my lord.
When?
9/4/2023, my lord. And thereafter, the petitioner approached to the police to make interfere with the matter. And police, though they have tried to settle the matter, but the matter has not able to settle. Even the petitioners and the respondents have filed a petition to the police, my lord. The police has not taken up the matter. Therefore, this petitioners has filed a title suit being number 77 to allow them to continue the premises and to make a fresh agreement. So what happened, well, thereafter, they filed one injunction petition to allow them to open the lock also, but the court has not passed any order as an interim relief, but the notice was issued, my lord. Thereafter, what happens, my lord? One petition is filed, that is page 40, my lord. 40, my lord.
Yes.
Is the petition, my lord. The subject matter is this petition, my lord. Page 40. It is in handwriting. The type copy is also there, my lord. Is 40. This petition is filed under section 151, allowing the petitioners to open the lock, my lord. But what happens? This petition has not taken up by the Landlord trial court, nor any order is passed, nor it is allowed to restart, and it is returned to the petition. That is the grievances of the petitioner. It is filed on 15/6/2023, my lord. Now, the premises is locked from 9/4/2023. My all the belongings, that is the clothes are there, my lord, is lying inside the.
Where is the order?
My lord?
Where is the order which was passed with the injunction application?
Injunction application is the order, my lord. It is at page, my lord. 33, my lord.
33.
33. 33. Petitioners are duly represented. Hardly engaged counsel for the plaintiff petitioner, fixing 3/7/2023 for necessary order. And thereafter, this necessary order is 34, my lord. Petitioner side is represented. Hardly learned counsel for the petitioner side. Petition is admitted. Issue notice upon the opposite party. Petitioner side is directed to take steps, fixing 17/7 service report and written objection, my lord. Then no any order is passed as to rejection of their interim pair or anything, my lord. Now, I am suffering for that. That's why this injunction, this 151 petition was filed, my lord, to take up the matter immediately.
Have the opposite party, have they appeared?
My lord,
in the suit?
They have yet not appeared, my lord, because the next date is 21/9/2023 for service report and objection, my lord.
Mr. Fukan, you have submitted that they have also filed a suit.
Yes, my lord.
For
I have appeared there, my lord.
for ejectment.
The ejectment.
Both the suits are not taken up together.
Not taken up together there because the suit which they have filed is only the pair is that I am, that means petitioner number one. is arrayed as a party there. The petitioner number, no, 2 is arrayed as a party, 1 is not arrayed as a party, and the pair is that I am unauthorized. That is the pair.
Nonetheless, since both the suits are connected,
Yes, my lord.
both are not taken.
Both suits are connected and the
No,
same
both of the suits are not taken up together.
can be taken up.
No, are they taken up together or separately?
No, separately.
See, technically going, if you are aggrieved by any order passed
lord.
in order 39 petition,
Yes.
your avenues under the court to file an appeal is there.
Right.
But here you say that you also filed a 151.
151.
But the prayer in 151 and order 39 is almost similar.
My lord.
The maintainability of this petition is still doubtful. But we are issuing notice.
My lord.
Perhaps we can, on their appearance, we can
My lord. My lord.
request the trial court to hear the matter on injunction.
My lord.
Have they filed objection?
They have yet to appear in my petition, my lord.
They have not appeared.
Not.
You have taken steps.
Yes, my lord. It is 21/9/2023 speaks for SR and objection.
No,
They have not appeared.
So prior to that, on 3/7/2023,
My lord.
the matter was taken up,
My lord.
fixing 17/7/23. Did you take steps or not?
No, I have taken step, my lord.
What happened on 17/7?
17/7, that they have not appeared, my lord. Service report is there only. 77, they have not yet appeared, my
We
lord.
have the copy of the order of 17/7.
Copy is, yes, my lord. 77 copy is not
Where?
there, my lord.
Not there. Last copy has page 35 is of 3/7.
Now it is fixed on 21/9/2023, my lord.
Third, DCC Senate Council for the petitioners have filed this petition under section 227 of the under article 227 of Constitution of India, being in connection with title suit number 77 of 2023, filed along with MISJ case number 52 of 2023 in the court of the learned Munsif number 1 Modigaon. Para. The Fukan, the learned council, has submitted that the suit has been instituted by the petitioners for a decree to continue to remain as tenant under the respondent. He also submits that another suit has been instituted by the respondent for rejection. The case projected is that on 9/4/2023, the suit premises, which is a shop, was blocked by the respondent, and since no action was taken by the police in spite of complaints and no settlement reached, the title suit was instituted along with the aforesaid case for injunction. However, no effective orders have been passed and only notices have been issued. Having no other alternative, the petitioner had filed another application on 15/6/2023 under section 151 of the CPC, praying for a direction to open the shop. It is the categorical statement of the petitioner that no orders whatsoever has been passed in the aforesaid application filed under section 151 of the para. The approach of the petitioner in filing an application under Article 227 of the Constitution of India is itself questionable. And the court provides for an appeal. Full stop. However, it appears that in the petition filed under section 151 of the CPC, no orders whatsoever has been passed. Under those facts and circumstances, let notice be issued, returnable on seventh of September. When is the next date? 9th.
21/9, my lord.
On 8th of September. That steps be taken for service of notice upon the respondent. By registered post daily, steps by tomorrow.
My lord, justice service may be allowed.
The Senate Council has also submitted that justice service may be allowed. Let accordingly that the respondents be served additionally by justice service, wherein the notices are to be routed through the registry of this court, and in such notice, the next date fixed is to be clearly reflected. Full stop. The petitioner is also required to file an affidavit prior to the next date of listing in this court in proof of such justice service. Full stop. Since the next date in the learned lower court has been stated to be fixed on 21/9/2023, an endeavor will be made to dispose of this matter on the returnable date on appearance of the party.
My lord, one pair is there, my lord. Yeah, one extra page is the next case, page number 10, my lord. It may be discarded, my lord.
Right now, let it remain. We'll
My lord, my lord. Oblige,
take steps tomorrow.
my lord.
Steps by justice within justice also tomorrow you take steps. You will give it before the court.
And I will file the affidavit. Oblige.
Wait, please, Lord.
Yeah.
In this case, my lord, the respondent has instituted the suit, my lord, for right title and interest in partition. What happened on the next day?
Your suit.
No, my lord. The
Respondent suit.
my lord.
You are the defendant.
I am the defendant. It was instituted in the month of for partition,
Partition.
right title and interest, and also issuing precept, my lord, to the authority for correction of my lord.
Precept after the partition. Okay.
My lord.
Then what has happened? Tell us.
Then on the next day itself, my lord, the suit was proceeded ex parte against the present petitioner.
Page
By order dated, your lordship will find
34.
no. my lord. Page 25.
But this suit is of 2021.
What is of my lord?
When did you receive notice?
Well, we have not received notice, my lord. Page suit is my lord, 3 of 2020, my lord.
Page
Page
25.
16.
Yes.
Page 25 is the order, my lord, proceeding ex parte against the present petitioner. On the next day itself, my lord.
Next day means
Suit was instituted on January, my lord, and case was fixed on 25/2/2022. On that day, my lord, the case was proceeded against the
first
petitioner.
January, 1/1/20, you stated the suit was instituted.
Yes, my lord.
1st of January 2020,
Not first, my lord. It is date was not mentioned in the month of January, my lord.
January.
Yes,
2020. Suit filed.
yes.
Thereafter, none.
By the order dated 25/2/2020, my lord, the next day.
Yes.
The suit was proceeded against the present petitioners, my lord. Page, lordship will find the order page 25.
Federal for releasing the council to pay term. Release served.
And that fact was not known to the petitioner's dependent there. When they came to know, they filed an application, page 30, my lord, under
Okay.
order 9, rule 7,
But there is an observation that you were served.
my lord. But there are other defendants, my lord, notice were served upon them, my lord, not exactly on us.
See, there is an observation, recording of the court.
Yes,
To
my
page 25.
that is there, my.
Summons issued to the defendant number 1
Yes,
and performer defendant numbers 3, 4, 6, and 7 has returned.
yes.
You are defendant number 1, isn't it?
3, 4, and 5, my.
3, 4,
2, 3, 4, and 5.
2, 3, at least 3 and 4 were served. Why didn't you appear?
Well, there has been 10 defendants, my lord. Notice was accepted by someone, my lord, not by the petitioners, my. Then, my lord, when they came to know, they filed an application, page 30,
30.
30, my lord, under order 9, rule 7, read section 151, my lord, for setting aside the order, my lord, proceeding expert against the petitioner. And that was registered as Miss J case 97 of 2020.
When did you file it?
It was filed on, my lord, 26/10/2020.
You were petition under
Order 9, rule 7.
for setting aside expertise.
Yes, ma'am. That has been registered as Miss case 97 J 2020.
And
And the date was, next date was fixed for objection, written objection against that petition by order dated 26/10/2022, my lord, fixing the case 15/11/2020.
where do you get?
Page 34, my. Last line of the order.
This is instead Miss J case 97.
My lord.
3, 4. You are 3, 4, 6, and 7.
Yes, ma'am.
Petitioners are 3, 4, 6, and 7.
Yes,
Defendant
yes.
3, 4.
Last line of the order, my lord, fixing 15/11/22.
This is 1610, 2016.
Yes, ma'am. By order dated 26/10/2022, my lord, it was fixed on 15/11/2020.
Yes.
Thereafter, the problem arises. On 15/11/22, page 35, the main sheet was fixed on 29/11/2020.
20?
Main suit
Yes.
that was fixed on 29/11/2022, page 35.
Yes.
While the Miss J case number 97/2020 was fixed on, my lord.
Yes.
15/11/22/11/2020.
Yes. It was fixed on 1511.
Yes, my lord.
What about on 1511?
On 15, since there's a Assam bond was called, my lord, the petitioners were not able to present before the court, my lord. That's why by order dated 22/11/22, the Miss J case was dismissed for default, my lord.
Where is it?
Page 37.
You should have given this for
Page 37. Last line of the SR, this suit is dismissed for default of the petition.
Not suit, the application.
The Ms. J case,
It is written suit.
my lord. It is written as suit, my.
Your application dismissed for default.
Yes. my lord. Although,
Order 9 Rule 7.
yes, that was dismissed for default. But learned court below has written as suit itself was dismissed.
Do you have the order sheet of 15/11/2022?
My lord, I have annexed the order, my.
15/11.
Yes, my.
Where?
Page 35 and page 36. There lies the problem, my.
But they could be present.
No, my lord. The,
Respondent plaintiff is represented.
my lord,
Respondents were represented. You say if there was an assembly.
my lord.
Petitioner plaintiff were-
The wrong order has been passed by the trial court below, ma'am. If the respondent is present in the suit, how can they, my lord, be absent in the Miss J case, my lord? Next page, page 37, 36.
Yes, this is the Miss J case is your case.
Yes,
isn't it?
my case,
You are the petitioner
my,
and you are the defendant in the suit.
yes, ma'am,
You are not present on the day.
my lord. In the
Very good.
suit, in the order passed in the suit, my lord, page 37. The learned court below has recorded that we are present, my lord. Paragraph number 3, my lord. Pro forma defendant 3, 4, 5, 6, 7, and 9, 10, and 11 are present.
Yes, where?
Page 35.
Five.
But in the Miss case, next page, the order passed in the Miss J case, my lord. The learned court below has held that we were not present in the court. And that's why that Miss J case was dismissed for default.
But were you actually present or not?
We were not present actually, my lord, due to Assam one call on that day.
Right. Oh, that Assam
Court itself has, order has reflected that. Thereafter, although an application was filed for, my lord, setting aside that ex parte order, page 38, that was not accepted by the land trial court below. And hence the present case.
38.
Yes,
Where is the order?
it was not accepted. It was returned to us, my lord. Page 38,
Second petition.
second petition. And now the suit is going on, my lord. And we have been busy.
When did you file this?
It was filed on, my lord, 13/3/2020.
Oh, will come. Why were you so late? This was in March.
Petitioners are very old woman. Most 80
What is
years
the
old.
present stage now?
Last order, my lord, it shows, my lord, for compliance of report, my lord. But it does not reflect what sort of report. Order dated 36 and fixing it 27/7.
What, TJ Sekar, Senate Counsel for the petitioners who have filed this application under. Cannot invoke both these provisions. Why do you write 1227 with 115? One is a constitutional
should be
provision
valid.
which you invoke
Yes,
if 115 is not available
my lord.
under Article 227 of the Constitution of India, being aggrieved by an order dated 22/11/2022, passed by the learned Munsif number 2, Tifsagar, in midday case number 97 of 2022, in title suit number 32 of 2021. The petitioners are the defendant numbers 3, 4, 6, and 7
Yes.
in the aforesaid title suit, which has been instituted for declaration of right, title, and interest, partition, and for issue of precept. Full stop. Para. Precisely, the learned counsel submit that the order sheet would reflect that the suit was instituted in January 2020 and on and on 25/2/2020 itself, the learned
Civil judge.
civil judge, Tifsagar, who had then taken up the matter, had passed an order that had passed an order of proceeding expert. Full stop. It is the categorical case of the petitioners that they were never served with any summons. Full stop. Accordingly, the petitioners had filed a petition under Order 9 Rule 7 of the CP, which was registered as Miss J case number 97 of 2022, in which, by order dated 26/10/2022, the next date was fixed on 15/11/2022 for filing written objection. It is submitted that on 15/11/2022, due to some burn call, the petitioners could not appear. However, by the impute order, the application under Order 9 Rule 7 has also been dismissed for default.
Yeah.
It is submitted that subsequently another application was filed on 13/3/2020 under Order 9 Rule 7 to set aside the aforesaid orders, no orders have been passed, and rather the petition, it is submitted, were returned to the petition. Issue notice return on 8th of September. That steps taken for service of notice upon the sole respondent by registered post with AD. Steps by tomorrow. full stop, para, three, like here. The learned counsel pays for an interim order. After hearing the parties and parties may have to hearing the learned counsel and or taking into consideration the facts and circumstances of it is direct that further proceedings of attitude number 32 of 2021 before the Munsif number 2 Sagar that remains suspended.
I'm all right.
The reported order would however be reconsidered on appearance of the court.
All right.
May it please your lordship.
Yes.
Lordship, my chance to file evidence on affidavit was closed by order dated 10/8/2017. Against those, I had preferred applications before the learned trial court.
They have been served.
The notices have been served, your lordship, nobody is appealed.
Yes, tell us your what? Petitioner is
Petitioner is the plaintiff in the suit, your
how
lordship.
many petitions?
Two.
Two petitions.
Two petitions.
Petitioners are plaintiffs
Plaintiffs in the suit.
for suit for
Suit for right title interest and recovery of past profit.
okay. Then what happened?
Your lordship, wide order dated 28/7/2017,
28.
7/2017,
Yes. Suit was which year?
suit 2015, your lordship.
15.
That will suit 3 of 2015.
Yes. 3 of 15. Okay.
In the year 2017, your lordship, 28/7/2017, we had filed an
28/7.
28/7/2017, we had preferred an application for adjournment for filing of PWs on affidavit. The said application was rejected on that date.
Rejected.
Yeah, rejected on that date. Whereafter, your lordship, on the next day, inadvertently, the council there had filed another application because on the previous date, no specific order was made closing the chance to file our evidence and affidavit. However, it was made clear on the next date, that is 10/8/2017.
10A.
10A.
Page.
It's on page number 16, your lordship.
16.
16.
What order? What was the order?
The order, your lordship, is the defendant. We had preferred inadvertently an application for adjournment that was rejected, and it was made clear that by the last order, an implication was made that our chance to file the PWs was already closed. Page number 16.
Yes.
Thereafter, your lordship, we had preferred two petitions, particularly one being a petition for allowing us to adduce evidence, and another
That was closed.
that was not closed, your lordship, but that was not even decided on merits. What happened is that two applications were filed. Along with this application, one application was filed under section 5 of the Limitation Act for condonation of delay. That was filed as an abundant caution, though that application was not necessary for allowing of that petition under section 151. But what the court had done is that, what the learned trial court had done is that this petition was decided. However, the petition for condonation of delay, it was rejected. But the main petition wherein we had prayed for allowing us to file the evidence, that was not, no decision was reached at that. That was finally rejected by an order dated 2/7/2019, which is the last annexure of this, annexure number 10 at page 39. By this order, your lordship, it was opined that on 21/12/2017, the plaintiff filed petition under section 5 of the Limitation Act along with affidavit by 1661 of 2017. Another petition number 1658 of 2017 is also filed by the plaintiff for allowing to adduce evidence. But petition number 1661 of 17 was already rejected on 16/3/18 by my learned predecessor. As petition number 1661 of 2017 has been rejected by my learned predecessor, hence there is no question of allowing petition number 1658 of 17. Therefore, in view of order dated 16/3/18, it is well understood that petition number 1658 of 17 stands rejected. That very petition, your lordship, 1658 of 17 is at page number 21, annexure 4. This, your lordship, was filed with the prayer to allow us to adduce evidence.
This petition was under what provision?
There is a non-quoting of provision, your lordship. The provision has not been quoted there, your lordship, but if I may rely upon the case of P.K. Palaniswamy, it is, your lordship is well aware that non-quoting of provision is not.
But what provisions are you invoking?
151, your lordship.
No, there is a specific provision in the code for allowing to adduce evidence. How many chances were given to you?
You were, your lordship. We sought for adjournment on 4-5 occasions, your lordship.
Yes, now what is wrong?
Your lordship, all I pray is that this application, which was for allowing us to adduce evidence, this was never decided. The application which was filed under section 5 of the Limitation Act, that was decided, but that was filed in abundant caution. Since that was the case and that was not statutorily necessary in this particular application, this application ought to have been decided on its own merit. However, no discussion as of same was made in this regard. It was merely decided on the ground, later on, way after in the year 2019, July 2019, it was decided that this application is also rejected on the basis of the application which was rejected for condemnation of delay.
Your main contention is that this rejection of this petition is without any reason, and the reason which have been cited is the rejection of section 5, which according to you was not necessary.
Was
at
not
all.
necessary.
How do you substantiate your argument? Section 5 necessary or not?
This, your
Was
lordship,
there any delay? Is there any time prescribed for filing this application?
151, your lordship, no time is prescribed otherwise.
Let us see your section 5 application. What did you understand at that time? Is it there?
It is there at page 17, your lordship.
17. How many respondents are there?
2, your lordship.
Proceedings have been stayed.
Proceedings have been stayed, your lordship.
See, you may be right in contending that the only consideration is the rejection of the section 5 application. There is no consideration as such. With one thing, since the respondents have also not appeared, will remand this matter. Will allow the petition, remand this matter to pass press orders considering the causes shown by you.
Petition number 1658.
Yes,
your
yes.
lordship.
Artistry and Chaudhary and counsel for the petitioners who has filed this petition under Article 227 of the Constitution of India, whereby challenge has been made to certain orders passed by the learned civil judge Bulaghar in title suit number 3 of 2015. At the outset, this court, by orders dated 16/6/2023 and 4/8/2023, has recorded that the respondent numbers 1 and 2 were served and have chosen not to appear. This court has also noted that the suit is of the year 2015 and the instant petition is pending since the year 2019, and therefore the case is taken up for disposal at the admission stage. The petitioners are the plaintiff in the suit which was instituted. Where have you seen for declaration of right, title, and interest and recovery of past possession, and was registered as title suit number 3 of 2015. Full stop. On 28/7/2017, an application was filed by the petitioner's plaintiff for adjournment and grant of time to file the affidavit, to file the evidence of the PWs on affidavit. However, the aforesaid petition was rejected. The said application was, however, accompanied with an application filed under Section 5 of the Limitation Act, on the assumption that there was a requirement to file such application, and it appears that the rejection was pertaining to the application filed under Section 5 of the Limitation Act, which was numbered as petition number 1661 of 2017. Full stop. However, since the petition for allowing adducing of evidence of the PWs, which was numbered as 1658/2017, was yet to be disposed of, the same was taken up for consideration, and the learned civil judge Bulaghar, by order dated 2/7/2019, has passed an order rejecting the same. The only consideration for such rejection was that since the application under Section 5 of the Limitation Act was rejected earlier by order dated 16/3/2018, the present petition number 1658/2007 automatically stood rejected. Full stop. It is submitted that there is actually no requirement of filing an application under the Limitation Act, as no period is prescribed under the Act to file such an application for allowing adducing of PWs, which was done by invoking the provisions of section 151 of the CP. It is submitted that therefore it was incumbent upon the Senate court to cite to consider the application seeking such indulgence on merit, which apparently was not done by the impugned order dated 2/7/2019. Sarah. The powers conferred on the court by section 151 is an inherent power which is required to be exercised for the interest of justice or to prevent abuse of process. It is a power which requires exercise of discretion on the facts and circumstances of the case, and such powers are not limited, and the only limitation is a self-imposed one, depending on the facts and circumstances of each case. Full stop. Para. This court is of the view that the contention made by the Chaudhary and counsel for the petitioner that a petition filed for allowing adducing of evidence on affidavit by the PW has to be considered on its own merit by discussing the reasons cited in such application, and rejection of an application filed under section 5 along with the application under section 151 section 5 of the Limitation Act, along with the section 151 cannot be the sole reason for rejecting the application under section 151 of the CPC, inasmuch as law does not prescribe or require filing of any application under section 5 of the Limitation Act. Para. This court is therefore of the opinion that the order dated 2/7/2019 is not sustainable in law, as there is no discussion regarding the rejection of petition number 1658/2017, except the fact of rejection of petition number 1661 of 2017 earlier, which was filed under section 5 of the Limitation Act. Full stop. Para. That being the position complete, this court is of the unhesitant opinion that the matter, that interest of justice would be served if the matter is remanded to the Senate court to decide afresh on the petition 1658/2017, which was filed by the petitioners, allowing them to adduce evidence by the PW. Full stop. Para. In view of the above, the instead direct by remanding this matter to the learned court of the civil judge Golaghat to decide. In view of the above, the impugned order in 2/7/2019 is set aside by directing the learned civil judge Golaghat to decide afresh the petition number 165/2017. Full stop. It is clarified that such consideration has to be entirely on the merit and as per law, and is not to be influenced by any observation made by this court in this order. The since there was an interim order passed by the court, the same stands vacated by directing the petitioners to approach the learned court below within a period of 15 days from today by filing appropriate application. With a copy of this order.
May it please your lordship. Regular first appeal, lordship. Today is the first time, lordship.
Regular,
Yes, lordship.
not
Regular,
irregular.
lordship.
What is a regular first appeal?
Lordship, first appeal, lordship.
Not a
Statute-
regular
stat-
first appeal.
Statutory appeal, lordship.
Why is it called regular? You file it regularly.
Lordship nomenclature given like that, lord.
Third, MS Third Senate Council for the appellant who is the plaintiff, who was the plaintiff entitled to number in Manuscript
Mani
34 of
Sudla, Lordship.
2017, which has been dismissed. Put up. Admit. There I call for the record. That step for service of notice be taken by usual process. How many respondents are there?
7, lordship. 8, lordship.
You will take registered proceeding
Yes,
as well as registered proceeding. Step within 2 days. List after 6 weeks. Along with service report and report on LCR. Call for the record. Hold on. Yes.
obliged.
Yeah.
Yes.
My lord, this appeal has been filed. That against the order by which our temporary injunction petition has been dismissed.
You are the plaintiff.
Plaintiff's petitioners. my lord.
Appellants are plaintiffs.
Yes, my lord.
So for
My lord, it is a suit for declaration and confirmation of possession, perpetual injunction, and specific performance of contract for sale.
yes. What happened?
My lord,
You filed an application identity injunction.
yes, my lord, we filed the petition.
Title suit number 32 of 18.
Yes. 32 of 18. In that case, my lord. The impugned order, my lord. Will take your lordship to the relevant portion only directly. Factual part we are ignoring in order to cut it short. 132, my lord.
132.
Yes, 132. My lord, before your lordship starts reading, my lord, the little background of the case, the defendant number 1 to 4, they had a plot of land, they proposed it to sell. And the plaintiff's petitioners, they agreed to purchase. They entered into oral agreement that the purchaser will pay 20 lakhs in advance, possession will be delivered, and 35 lakhs will be paid at the time of registration. On that understanding, my lord, 20 lakhs was paid by the plaintiff petitioner. Possession was handed over to the plaintiff petitioner and applied before the deputy commissioner for self-permission. After getting possession, my lord, the plaintiff petitioners, they started development works. It was a barren land, low land, so they started development works and construction of the boundary wall. At that point of time, my lord, some of the owners of adjacent plots, they raised objection. Then defendant number 1 to 4 and the plaintiffs, they jointly signed FIR and lost before the police. Police intervened and solved the problem. Thereafter, the plaintiff petitioners, they constructed residential house, they established shop, go down, gumtis, some were rented out. In that way, they were enjoying the possession over the
When was this? When was this?
2011, my lord.
2011.
Yes, September 2011,
He had,
oral agreement was
he had
entered into.
completed the construction.
Yes, they constructed residential house, some gumtis, then shops, go down, everything. The land was developed and improved, my lord, into a commercial place. The landowner, they caused delay to obtain this help permission on this and that plea. Meanwhile, my lord, third party approached the landowners and they made conspiracy. They submitted another application behind the back of the plaintiff petitioners for self-permission. Then the assistant settlement officer, he issued notice to the plaintiff petitioners and date was fixed for hearing. After collecting report and after hearing, self-permission was refused to the third party.
Okay.
Having failed to obtain the self-permission, my lord, they adopted backdoor policy. They applied for partition of the land. Overnight, they got the land partitioned. And by using the new patta number and that number, they applied again for self-permission. And they obtained self-permission. Sale deed was registered. After getting the sale deed registered, that third party, my lord, they are trying to dispossess the plaintiff petition. Under these circumstances, this title should have been filed. PS 32 of 2018 has been filed along with a petition for temporary injunction. Unfortunately, my lord, that injunction petition was dismissed. But all these developments after dismissal of the earlier petition for temporary injunction. Earlier petition for temporary injunction, that was, my lord, dismissed.
Earlier means there are two applications.
My lord, when the title suit was filed, along with that, a miscase was filed for temporary injunction that was numbered as 63 of 2018. That was dismissed on 17/12/2019.
63 of 2018.
Yes, 63 of 2018, miscase number. That was dismissed on 17/12/2019.
Dismissed.
Thereafter, my lord, all these developments have taken place. Subsequent events, this new application, then partition of the land, new DAG number, pattern number.
And you filed a fresh
sale deed.
application.
Yes. Thereafter, we filed amendment petition. Because of the subsequent development, amendment petition was allowed. And we submitted the amended petition, my lord, the amended petition we filed, my lord, the amendment was allowed by order dated 3rd January 2023. Amendment order was.
Then you filed a consolidated claim.
Yes, we filed the consolidated petition, my lord, thereafter plaint. And my lord, along with the present petition for temporary injunction. Now, my lord, your lordship kindly come to page 132.
132, yes.
Directly to the relevant portion. My lord. Here your lordship will find, my lord, the code below.
What is the nature of injunction you are praying for?
My lord, the nature of injunction, we have prayed that the defendant should be restrained not to issue the self-permission, then a specific performance of the contract.
No, the sale has already been registered, you have said,
My
with the third party.
lord.
Now, what is the present injunction you are seeking?
My lord, we are seeking not to disturb the possession of the plaintiff petition because they have taken the permission, sale deed has been registered. So after registering the sale deed.
Is any counterclaim filed?
No, nothing they have filed.
Counterclaim till now has not.
They have not filed.
Written statement filed.
A written statement filed. Then after amendment, additional written statement has been filed. And in the petition for injunction, they have filed the written objection also. They have filed. So, my lord, after considering all these things, the code below there has categorically, my lord, here your lordship will find.
Why has it been held that you have suppressed material facts?
My lord, we have not suppressed any material
That is the
facts.
finding of the court.
Yes, my lord, finding of the court, we'll go through it. My lord, here, the code below has categorically given the findings on 3 golden principles of granting injunction. Prima facie case, balance of convenience, and irreparable loss. These are the ingredients for issuing the injunction. Here your lordship will find at page 132, I am reading, my lord. Now, as the matter pertains to the granting of, my lord, little down, page 132, little down I am reading.
Yes.
Now, as the matter pertains to the granting of injunction, so it is incumbent upon us to see as to whether plaintiff petitioners are able to establish the 3 golden principles of granting temporary injunction, that is prima facie case, balance of convenience, and irreparable loss in his favor to get the relief of injunction. As regards the prima facie case, the case record reveals that the principal defendant of 1 to 4 in their pleadings at para 29 had categorically pleaded that there was an agreement to sell between the plaintiffs and defendant 1 to 4 in respect of the shoot land, and they have also made an application for sale permission, but as the price could not be finalized, so the opposite party 1 to 4 has applied for cancellation of the sale deed as sale permission, and according to them, matter ended there. That was their application. Now, if that be a position, then in my considered opinion, the aforesaid admission of the defendant number 1 to 4 clearly indicates towards the fact that the plaintiff has raised a bona fide dispute, which requires adjudication on law and facts. And as such, I am of opinion that the prima facie case lies in favor of the petitions. Next, my lord. Now, as regards the balance of convenience is concerned, it is pertinent to mention that as per the land holding certificate, land possessing certificate issued by the ASO, means Assistant Settlement Officer, issued by the ASO, as well as the report of the police officer in non-FIR case number so-and-so, coupled with the order of the executive magistrate passed in Ms. J case number so-and-so and Ms. J case number so-and-so, the possession of the shoot land, my lord, this line is important. The possession of the shoot land prima facie appears to be with the petitioners. Petitioners are in possession. So in view of that matter, I am of the considered opinion that the competitive hardship would be to the petitioner as they would be deprived of the occupation and enjoyment of the shoot land till the merit of the case is decided in due course. Hence, the balance of convenience, in my considered opinion, lies in favor of the petitioner. Next, my lord. Now, as regards the irreparable loss is concerned, the case record reveals that the opposite party 1 to 4 had already resold the shoot land.
All the have been held in your favor.
Yes,
Thereafter, why
all the three in our favor.
and why again?
Yes, my lord, then my lord kindly turn to page 135.
Yes.
Two law points. The court below has said that 2 law points raised by the other side, our petition has been dismissed. Here, my lord, at page 130.
Res judicata.
Res judicata. Number one, first point, court has held res judicata. Our second petition is barred by res judicata.
And what is the second point?
Second, my lord, that the other side has raised the question that we have not prayed for permanent injunction. Permanent injunction we have prayed for, we'll show your lordship. We'll show your lordship. It is there. So these 2 grounds, barred by res judicata, second application.
Okay, we'll come at
My
2 o'clock.
my
It come up for the first time.
yes.
Sorry. Is that your number? A Mullah. Then it counts for the evidence who has preferred this appeal against an order dated 15/7/2023 passed by civil judge senior division Dubri in case number 06 of 2023 arising out of title suit number 32 of 2018 by the impugned order, the prayer for injunction has been refused. The appellants are the plaintiffs in title suit 32 of 2018, which was filed for declaration and confirmation of position from a perpetual injunction and specific performance of a contract for sale. Have you seen this? Along with the state title suit, to Mijik is 650 of 2018 was filed under order 39 rule 1 and 2 of the CP, by the order dated 17/12/2019, the same was dismissed as at that point of time there was no requirement to pass any injunction order. It is the projected case of the appellant that the appellant had agreed to purchase a plot of land owned by the respondent defendant numbers 1 to 4, in which an advance of rupees 20 lakh was paid and possession was handed over in the year 2011 itself. The agreement between the parties was that the remaining 35 lakhs would be paid at the time of registration of the sale deed, and accordingly, sale permission was applied for. as possession was handed over, comma, the appellants claim to have developed the plot of land, constructed houses and boundary walls. He has also, the learned counsel has also submitted that since some disturbance was created by neighboring persons, comma, a joint affair was lodged in the year 2011 itself by the plaintiff petitioner, by the plaintiff, by the appellant plaintiff and the defendant. Para. The matter took a turn when the defendant delayed in registration of the sale deed with an ulterior motive and applied for sale permission with a third party. As such permission was initially refused, comma, the a modus operandi was adopted by getting the land partition and sale permission was again applied for with new numbers. And ultimately, comma, the respondents, defendants were successful in getting a sale deed registered in favor of a third party. Full stop. Para. Under those facts and circumstances, comma, the petitioner, the appellant plaintiff filed an application for amendment, which was allowed by the learned civil judge Dubri on 3/1/2023. At the same time, comma, since there was a threat of disposition, comma, the appellant filed a fresh application under Order 39, Rule 1 and 2, with a prayer not to disturb the peaceful possession. Full stop. Para. The learned court below by the impugned order dated 15/7/2020 has, however, rejected the application which was registered as Ms. J case number 6 of 2023. Full stop. A reading of this impugned order would reflect that while all the three golden principles, namely prima facie case, balance of confidence, and suffering of irreparable loss, have been decided in favor of the appellant plaintiff. However, mainly on the ground of res judicata, comma, the application has been rejected. Full stop. The state consideration is derived from the fact that earlier Ms. J case number 63 of 2008, which was filed for injunction, was rejected by order dated 17/12/2019. Full stop. Para. Admit. Call for the record. Admit. At this stage, that can copies of the records be called for. That step be taken for service of note upon the respondent by registered post by user process as well as by registered post. However, MS D does Vermont Learned State Council accept notice on behalf of respondents 8 and 9. That extra copy be served upon her within 2 days. Steps accordingly be taken for rest of the respondents as directed above. List after 6 weeks, along with service report and report and scan copies of the case record in the IAU, right? Artri J. Mullah, learned counsel for applicant, appellant, who by means of this application has paid for grant of injunction pending disposal of the connected FAO 43 of 2023. Full stop. Para. The said FAO has been admitted today. That is present. Para. Elaborate discussion has been made in the state order of admission. Full stop. The rejection, the impugned order by which the injunction has been rejected would reflect that impugned order dated before 2023 would reflect that while the three golden principles, namely prima facie case, balance of convenience, and suffering of irreparable loss, have been held to be in favor of the applicants, appellants, only on the ground of res judicata, the application which was registered as Miss J case number 6 of 2023 has been dismissed. Full stop. This court is of the prima facie opinion that the earlier rejection of a similar application in the year 2019 cannot be a ground for consideration of the present application of the subsequent application for injunction, as not only there were change in circumstances and change in facts and circumstances, the amendment to the plain was itself allowed on 3/1/2023, wherein the defendant had also filed amended WS. In view of the above, this court is of the opinion that a case for grant of injunction is made out. Issue notice returnable on 8th of September. Let steps be taken for service of notice upon the respondent by usual process as well as by registered post 89 readers. After hearing the learned counsel for the applicant, appellant, till the returnable date, is directed that the defendant, that the opposite party defendant shall not cause any disturbance to the peaceful possession of the suit land, which is under the peaceful possession of the appellant applicant over the suit. The aforesaid order would, however, be reconsidered on the next day end of the court on appearance of the party.
Massive.
Take steps in both the matters.
But yes.
Right, Ms. Lordship. This is an appeal under section 37 of the Arbitration and Conciliation Act against the order passed by the Landlord Civil Judge.
Section 8.
Section 8, Lordship. Refusal, section 8. Also, respondent number 127 filed the suit.
That's correct. You are the defendant in the suit.
Defendant number 1 to 4.
Suit for
Suit for specific performance of the development agreement. We are the promoter, respondent number 1 to 7 are owners of the land along with their co-sharers. But for specific purpose of development agreement and the specific purpose of supplementary agreement and other pair. And in that suit, they have made defendant some of the purchaser of the flats as defendant number 6 to 36. Ignoring the,
you, who are you?
I am defendant number 1 to 4.
Who are you?
1 is the promoter, 1 and 2, 3, 4 are the directors.
They are the promoters and directors.
Promoter directors, promoter company and director. Admittedly, there is arbitration clause. So we file an application under section 8 for referring the parties to the arbitration.
You filed a section 8 application.
Section 8 application.
Okay.
They filed objection, but on 2 grounds. Number 1, there are third parties, non-signatory to the arbitration agreement. And secondly, that cause of action cannot be bifurcated. Now,
Yes.
therefore, the impugned order has been passed. It is running 35 pages from page 106.
There is some
Relevant lordship page 136.
136.
136. I would refer to 136. Start from 106. Here is a case, lordship. This is the.
Here is the case.
Here is a case where except the plaintiffs and the defendant number 1 to 5, other defendants are not parties to the arbitration agreement. This is how the suit is framed. And whether or not the defendant number 1 to 5 was induced by other defendants to breach the agreement, and thereby the plaintiff got a cause of action to claim the reliefs of their share, cancellation of sale deeds along with other reliefs against all the defendants is a question to be decided at a single platform. The non-signatory defendants cannot expose to arbitral proceedings. Cause of action against all the defendants is stated to be same and it cannot be bifurcated. Further, learned counsel appearing on behalf of the defendants vehemently argued before this court that after amendment of section 8 of Arbitration and Conciliation Act, the ratio given in the case of Sukanna holding become irrelevant and same is not applicable. In the backdrop of the submissions of the learned counsel for the defendants, this court has considered the new amendment brought in Arbitration and Conciliation Act on January 1, 2016 with effect from 23/10/2015, and it finds that in section 8, the words "a party to the arbitration agreement" or "any person claiming through or under him" were included to replace the word "party." The inclusion of these words obviate domestic arbitrations are now in the line with the ratio of fluoro controls insofar as the non-signatories to arbitration agreements are concerned. It is now permissible under section 8 for non-signatories to enjoin in arbitrations. Then admittedly, the Sukanna holdings laid down 2 broad propositions of law, which were as follows. Bifurcation of the causes of action as a procedure is not contemplated under the Arbitration and Conciliation Act, and the words "a matter" indicate entire subject matter of the suit should be subject to arbitration agreement. 2. An application of section 8 of the Act would not be sustainable in a suit as to matter which lies outside the arbitration agreement and is also between some of the parties who are not parties to the arbitration agreement. As regards this aspect of bifurcation of causes of action, Sukanna holdings is still good law. This aspect was neither overruled by chloro controls, nor has the amended in Arbitration and Conciliation Act made any reference to this aspect. Therefore, bifurcation of cause of action is not permissible under law. This was also fortified by the division bench of the Delhi High Court in Amit Lachan.
When was the this suit instituted?
2022.
22. And you had filed this section 8 application when?
In 2022.
Page 82, Lordship, our application is at page 82,
And this order is of June 2023.
June 2020. We
You have
filed on
not-
11/11.
You have not filed your WS.
No, we have not filed our release.
Yes, madam.
Let please, your lordship. Lordships, in the light of the operative part of the judgment, lordship. Sukanya Holdings Private Limited holds the field, and bifurcation in that
We'll
case
do
is.
one thing, we'll hear this matter. We'll admit it and we'll fix it for hearing. We'll not delay this matter. Today, since they are already appeared, other respondents, are they necessary to be?
It's necessary. Some of them also filed section 8 petition, Lordship. Purchasers. They also
That-
filed a separate.
It's a right for whom?
No, he is with me.
How many respondents? Who are the respondents?
45
I have
respondents,
appeared for
Lordship.
1 to 7, lordship.
How many respondents are there?
40, 45, 48, Lordship.
48.
1 to 7 at the plaintiff.
They were defendants in the.
See,
So-
Mr. Forecaster, this order
Lordship.
has contained reasons, and
It's a very.
reasons on the first blast does not appear to be something
I can,
which is irrelevant.
I can
But
distinguish,
this
Lordship.
this being an appeal, we'll
Appeal.
admit this and hear it on an early date.
Lordship, I have no objection.
No stay may be granted, lordships.
No,
It will delay the matter.
Till-
no, we'll fix a date for hearing.
Right.
Immediately on the notice, service been complete, we'll make it explicit. Because if the suit proceeds, it will not be in the interest. You have filed a separate application.
Yes, Lordship.
For preemptive protest, when it comes. Otherwise, section 8 mandate is very clear, but
Clear.
the
Lots of,
discussion which he has made,
The
that bifurcation, that perhaps will need some deliberation.
Yes.
exceptions are carved out. Lordships are very clear that these exceptions are
That is why we
preconditions,
intend to hear you.
preconditions.
As the learned counsel who has preferred this appeal under section 37,
37(1)(a).
37(1)(a) of the Arbitration and Conciliation Act 1996. Assailing an order dated 27/6. It's appealable order.
Appealable order under 1A, Lordship.
27/6 were passed by the learned civil judge number 1, Kamrup, and
After amendment, it has been made.
case number 1007 of 2023, arising out of title suit number 358 of 2020 by the impute order. The aforesaid petition has been rejected. Aforesaid petition which was filed under section 8 of the act has been rejected. About the Arbitration Conciliation Act 1996, the herein after the act. Paragraph. The appellants are the defendant numbers 1 to 4 in the suit which was instituted for specific purpose of a development
Agreement.
agreement. The appellants are the promoters and directors of a company who were interested with the state development work over the plot of land owned by the
Respondent number 1 to
1
7
to 7.
can,
1 to 7,
as well as pro forma respondent.
as well as the pro forma respondent.
45.
The forecaster, the learned counsel for the appellant has submitted that since there was an arbitration clause to resolve any dispute, an application under section 8 of the act was filed at the first opportunity for passing an order of referral to the referral of the matter of the dispute for arbitration. However, by the impute order dated 27/6/2023, comma, the application has been rejected by citing certain grounds, including the ground that many of the affected parties
Are not
were not
parties to the
signatories to the agreement, and there would also be bifurcation
application of the
of the cause of
causes
action.
of action.
The reasons cited are can be matters of deliberation. Admit
Chip, the case is fixed on 11th. Anyway, they have all appeared in the law court. So if they, through that, we can serve the notice that on that particular day. That would entail, otherwise it would entail. delay.
admit at this stage record did not be called. That steps be taken for service of MS
Yes.
S. Chakraborty, Learned Counsel, has appeared for respond numbers
1 to 7.
1 to 7. And therefore formal steps need not be taken on the state respondent numbers 1 to 7.
We are caveated.
However, extra copies may be served upon her.
We have served copy
1 to 7 on the basis of on the strength of her caveat. Caveat to be declared for him. Did you find any pass any orders in the caveat?
No.
No.
Will pass. That step for service of notice
I didn't know.
upon the respond numbers 8 to
48.
8 to 48. We take it by
On the count.
usual process as well as
Then
by
on the
state process.
council, if
We cannot just have it by the
No.
council. If you refuse this matter
then
as well as by, you take by state post also, as well as by state post. This court has been informed that the matter is fixed before the learned civil judge
yes,
on 11th of
August, 11/8,
11/8/2020.
civil judge number 1.
2023. The court typically Learned, the learned counsel for the appellant may also serve the remaining respondents through their counsel, as this court has been given to understand that all the respondents have appeared in this suit. List on right in the caveat. Third, MS talk about the learned counsel who has called this caveat in with respect to an order dated 27/6/2020 passed in Hagorpati. The caveat would be heard in the event this court proposes to pass an interim order. There are caveat stands heard. I heard learned counsel for the applicant also heard MS as talk about learned counsel for the respondent was 1 to 7.
7.
The instead application has been filed in connection with an appeal being FAO number 45 of 2023 filed against the state appeal has been admitted today. That is the learned counsel the forecaster for the applicant submission an interim order may be passed in absence of which the entire appeal may be rendered in progress. Considering on the other hand, MS Chakraborty has submitted that there is no requirement
Unnecessary.
to pay the proceedings. After hearing the parties, this considered opinion that an interim order is warranted in this case. Also, at the same time, this court is, we cannot be oblivious of the fact that delay in this matter would not serve the interest of justice. Therefore, balancing the interests, comma, it is directed that till the returnable date, comma, the further proceedings in statute suit number 358/2022 in the court of the civil judge number 1, Kamrup M, shall remain suspended. It is however made clear that on the returnable date and oblique or on appearance of the contesting parties, comma, an endeavor would be made to dispose of the entire appeal. I according with them. Have we given a date? We have not given, we would give a date. Returnable on question, date. We'll have it on. What about 12th of September? It's a Tuesday. But come prepared.
We are prepared.
No, not only you. You inform the parties who would be appearing that on the date, not only for appearance, they can come for hearing.
Right.
May I please, my lord, this is an appeal against the order passed by the ESI court, madam.
ESI.
ESI court.
MFA.
MFA, my lord. My lord, the first incident happened, my lord, when the ESI authorities in 2008, my lord, issued a notice to us. I'll just have, before I take my lord to the orders, I'll just have my lord's attention at that page 63D, my lord.
When was it? When was
My lord, this was on 23/6/2008. Page 63, my lord.
2008.
8, my lord.
63.
Page 63. The type copy is at page 63. The original, my lord, would find at 63D. If my lord can just have that original at 63D, my lord.
Yes.
My lord, implementation of the ESI Act 1948 and registration of employees of the factories and establishment under section 212 and 15 of the Act as amended. Now, my lord would see 1. It is informed that under section 13 of the ESI Act 1948, the central government has wide notification dated so and so, dated nil, made the provisions are applicable to all factories establishments covered under the Act within the area of Golaghat. So basing on this, my lord, thereafter we did not do it. They quantified the data, the amount at page 67, madam. And in the meantime, we had given a reply that we have a hospital on our own and all our employees, my lord, are above the threshold level. Page 67, madam. This is, I just have my lord's first attention, first line. I have to state that under section 40, read with section 39 of the implement so and so, hereby, the principal employer of the establishment covered under is required to pay in respect of every employee, both employees' contribution and so in Rule 51 of this so and so as amended. My lord, they are exercising power under 40 and 39, read with Rule 51 of the general rules. Now, the amount quantified is at 67B, my lord. This came in 26/7/2010, and the period is, my lord, contribution calculation. Contribution period is from.
You did not reply to the first notice.
We said we are not covered.
Where is the
my lord, that reply is not there, but it's my lord, it's there.
Have you made any statement that you have?
Yes, we have.
Where?
My lord, when I take my lord through the judgment, I'll show it now. It's there. My lord will just have this, my lord, 6/8 to 3/10. And the amount is 1,86,24,320. And my lord would see.
Yes.
They have, my lord, held the minimum salary as 5,500 and then they did. Now, my lord,
Where do you get?
my lord, that last line, last figure, my lord.
Where?
2368 is the number of employees. Then 22 is the, my lord, period, months, and 5,500 is the, my lord, minimum salary. Then, my lord, when this was done, we, my lord, approached the ESI court, my lord, by filing this application, my lord, at page 52.
This present is under 75 over.
This initially was under 7, that we had proceeded under 75, my lord, before the court. First, the waiver was not given. Then we approached this honorable court, single judge dismissed it, writ appellate court allowed us, my lord. The waiver was granted of the under that 75B. Then, my lord, would have page 55. My lord's application is 52, page 55. Para 3, my lord. I'm not taking, my lord, to para 2, wherein we said that we have hospitals, this, that. I'm not taking, my lord, through that. Para 3, my lord.
Page 55.
55, my lord. The petitioner begs to state that on 23/6/2008, one letter was received from the director wherein it was informed that by notification dated nil, all factories establishments under Golaghat were bought under so-and-so. However, the said letter does not contain on which date the said notification was issued, but it only stated that from 1/6/2008, the Numaligarh refinery was covered under the provisions of the Act. It also stated that the branch office of the so-and-so at Jorat has been asked to render necessary assistance. More peculiarly, the said letter, the respondent asked the petitioner to give publicity of list of employees of so-and-so. However, most peculiarly, while the said letter was forwarded, there was no ESI office in Golaghat and there was no doctor or dispensary in ESI in Golaghat district. So, my lord, this is what we projected before the court. Now, my lord has seen that letter of 23/6/2018, by which, my lord, nil letter, they said it was applied. But, my lord, if lordship comes to page 50, the provision 50, the provisions of the Act, including, my lord, section chapter 4, which contains section 38, 39, and 40, page 50, this was made applicable to Golaghat district. In exercise of powers conferred by subsection 3 of section 1 of the Employees Insurance Act so-and-so, the central government hereby appoints 1st day of January 22 as the date on which the provisions of the said Act. My lord, I have shown, my lord, where they have made that calculation, section 39 and 40. This came into effect, my lord, in Assam, the names of the district, second line, first name, Golaghat. It came into effect from 1/1/2022 only, my lord. That is the Act, my lord. So these, my lord, we had taken a plea there, but, my lord, this document unfortunately was not before the ESI court, my lord, when the order was passed. Be that as it may, my lord, the ESI court, my lord, while order, my lord, would find it at page 35. 18/3/2023, my lord. The facts were, my lord, all those documents show cause was it. My lord's query, my lord, were page 37, first paragraph. After receiving the said notice, dated 21/7/2010 and 26/7/2010.
This is dated 18.
This is 18/3, my lord.
Impute order.
Impugn order. ESI case number 3 of 2010.
Yes.
My lord, in the first part, the facts have been stated how that amount was calculated. Second part, my lord, page 37, my lord, first paragraph.
Yes.
My lord, after receiving the said notice dated so-and-so, the company-wide letter dated 16/8/2010 informed the respondent that the company is providing all medical facilities to its employees. As such, it should be exempted from the provisions of ESI Act 1948. Then, my lord, the honorable court, my lord, framed issues which my lord would find
Issues are at 39.
39, my lord. Whether the impugn assessment issued by the so-and-so is and liable to be quashed, whether the show cause against the is illegal and required to be quashed. Then 3, whether the petition is entitled to relief, to what relief. Now, considering the first 2 issues, my lord, the conclusion, my lord, would find at page 46, my lord.
Yes.
Second paragraph. What crystallization from the above discussion and observation is that the plea of the petitioners that the provisions of the ESI Act are not applicable to the contractual workers under the contractors employed in the establishment are not applicable to them, nor the contractual workers of the contractor in their establishment are not their workers is not tenable. Accordingly, both the issues are answered in negative and against the petitioner. Then, my lord, this is what I'm trying to do. Both the 3 and 4, my lord, both the issues are related to the relief of the parties taken up simultaneously and discussed. So-and-so appearing for the ESI argued that the case of the petitioner suffers from non-jointer of the contractors and the contractual laborers. On this count alone, the case is liable to be dismissed. In support of our submission, learned counsel referred to the decision of the Honorable Supreme Court in so-and-so. Here, one paragraph I would like to place, my lord, page 47. The non-jointer has been taken up. Para 6, my lord, page 47, top bold portion, my lord. Labor statutes are meant for benefit of workmen, hence ordinarily in all cases
This is
under...
quotation from fertilizer.
Yes, my lord. Here, only one thing I just would like to point out, my lord. Labor statutes are meant for benefit of workmen, hence ordinarily in all cases under labor statutes, the workmen, or at least some of them in representative capacity, or the trade union representing the concerned workmen must be made a party. So, my lord, 3 aspects, either the all representative capacity or the trade union. Now, the conclusion basing on this is at page 48, my lord. He again reiterates that, copies that, my lord, order and the next paragraph. In view of the above, it is found that the case of the petitioner suffers from serious defect of non-joint of necessary party, that is, the contractor and the contractual workers. So the case is liable to be dismissed. Now, what had happened, my lord?
Who are the parties?
My lord, that's what, my lord. Page 93, my lord, will come. ESI miscase number 6 of 2019.
93.
93, my lord. In the High Court, my lord, the earlier proceeding, we had made them party, but in the original suit, it was not there. Subsequently, when the matter was remanded back, my lord, we filed this application for implement of the Numaligarh Refinery Employees Union as party respondent number 4. Now, that order, my lord, would find at page 97. My lord, both parties are present through answer. Here, this case has been restarted in a petition for impleading so-and-so as opposite party number 4. The other side submits a petition stating that it has no objection. On perusal of the record, it appears so-and-so is also one of the necessary parties, and the petition is allowed. In the main case, the ESI so-and-so, the Numaligarh Refinery Employees Union, be added implemented as respondent number 4. So, my lord, that conclusion that either of the 3 permitted parties were not there is wrong, my lord. But I would like to, my lord, urge before your lordship that the very proceeding which was initiated by the ESI authorities in 2008 was without jurisdiction, my lord, because these provisions made applicable from January 2022 only. Because that is why, my lord, in that first letter.
This appeal is for the judgment of 18/3/23.
18/3/23.
The only consideration is non-jointer of party.
Finally, my lord, it was dismissed on that. It's only on that, my lord. Finally, it was dismissed on that. And the other two, my lord, he said it's decided against us, but that is not the final conclusion. The final conclusion is, my lord, non-jointer of parties. Whereas, my lord, the judgment that they are.
Have you framed substantive? petition?
Yes, your lordship.
You're required to frame substantive. petition.
Yes, your lordship.
Where? page?
I'm just giving it. My lord. My lord would have it as page 27, my lord. I would request, my lord, 1 and 7, my lord.
One is not substantive. petition.
My lord, that 1, 3.
Quarter judgment.
Quasi judgment, it will be 7, my lord.
We'll examine the judgment. We'll leave other questions open.
Lordship, my lord will have 7, my
You
lord.
raise this whenever if you are successful
Lordship,
and we remand this back
lordship,
for fresh consideration.
my lord, I will
You
have
raise
it.
this issue.
Lordship, lordship. My lord will have 7 then, my lord.
As party respondent.
As part.
You've done it in a
Oh,
hurry.
sorry, my lord. You will part
Correct.
respondent.
Correcting there will not do.
No, I'll correct it then.
Will not allow you to correct.
Earlier system, my lord will give a.
It's gone now. All under monitor, scanner. You correct here, it will not be corrected in the system. So you need to file
But this
application.
has not been uploaded in the system. Upload when? This may not be uploaded. The post title goes well. This may not have gone. So I may have a chance for it.
No, this is okay. Third. Three,
The correction.
Nair Learned Senior Counsel assisted by MS A. Verma for the appellant. The appellant, Mrs. Numaliga Refinery Limited, has presented this appeal under section 82 of the Employees State Insurance Act 1948 being aggrieved by an order dated 18/3/2023 passed in ESI case number 3 of 2010. So the Learned Senior Counsel, while referring to the impugned judgment, has drawn the attention of this court to various discussions made therein, it ultimately transpires that the application, that the appeal, it's an appeal,
It's an appeal, my lord.
appeal was rejected on the ground of non-jointer of parties. Full stop. The- This 82 is appeal.
No, it's a petition, madam. Just have it punched.
The case don't say appeal case. The senior counsel has drawn the attention of this court to an earlier application which was registered as ESI case number 6 of 2019, filed in the main case for implement of
Appeal.
party respondent,
Mhm.
which was duly allowed by an order dated 28/11/2019, whereby the Numaligarh Refinery Employees Union was implemented as opposite party number 4. The senior counsel accordingly contends that the requirement laid down by the Honorable Supreme Court in the case of Fertilizer and Chemical Travancore Limited versus Regional Director ESI reported in 2009 to comply with, and therefore the finding of Senate ESI court is apparent erroneous. The appeal is admitted on the following substantial question of law. Number 7. Page 27. Uh, this court may frame any other substantial question of law at the time of hearing after giving adequate opportunity to the affected part.
Gotcha.
Call
There
for
is
the
a-
record. Let steps be taken for service of notice upon the how many respondents? Upon the
Malad
respondents
4.
by usual process as well as by registered court which is the steps within 2 days. List after 6 weeks along with the record and report on service.
Gotcha.
Yeah, why?
There is an IA 2186.
Or so and so, report for the applicant who has filed this I for the they will not help you.
Because Malad, the stay will not help us, but they are now issuing notices for Malad.
You have not paid for any stay of any such proceeding.
No, because we have, if the judgment is stayed, Malad,
Judgment is your application. Judgment has rejected. Saying a rejection is what will going to help you.
because
You have to
Malad,
pray for injunction.
that's true, Malad.
You have not even thought about it.
Malad, yes, your lordship.
Saying the judgment is not going to help
And
you.
my lord, subject to what my lord would say, the last part, if my lord can help me, and or to pass such further orders as your lordship may be.
That is too vague. You file an application.
We'll file an application.
Senate Council, this is however, this court is has noticed that proper relief,
Has not.
that proper relief has not been paid for in this petitioner is given liberty. At this stage,
Withdraw.
three Nair and the Senate Council praise submits that he may be allowed to withdraw this
Lordship.
with the liberty to file a fresh
Lordship.
according to ISN's dismissal and withdrawal with liberty.
Lordship. Much obliged.
File it immediately.
And yes, ma'am, tomorrow it's okay.
Yes, madam. Item number
I'm appearing for respondent lordship.
14. A. Kulita.
Yes.
Railway case
Failure to serve.
that
MSA.
apportionment
Lordship.
8 lakh.
Lordship.
Very cheap. We could have come for the first time.
Lordship.
You take instructions, we'll issue a short notice. We'll dispose this off at the end. Or let her be present, not be two. None appears for appellant on call, whereas MTV, where RTV. And this is present for the railways for interest of justice. Please speak, please, in the next.
16 also same lordship.
Very strict. 16 is the same concept.
Lordship.
Footnote.
Obliged.
State to appeal against the RCT's order, lordship. The goods case, lordship, regarding punitive charges, lordship. Although it was a misdeclaration, honorable court held that the punitive charges under that.
They have, beside the issue another provision of 73, it should be 66 Lordship.
So both are similar.
Lordship,
Both are similar.
Lordship only
What
one,
is- what is-
there
what
is
is the-
a IF for XP Lordship.
How much is the amount run?
Lordship, 2,89,282. That was already they have deposited Lordship. When the charge was collected as a misdeclaration, they have deposited. They claim for refund it Lordship.
That refund has been allowed.
Refund has been allowed Lordship. Against that we have come. Lordship.
Our take over and council for the appellant who has preferred this appeal. The section 23
Lordship,
of
Lordship.
the Railway Claim Tribunal Act 1987 being aggrieved by a judgment and order in 28/4/2023 passed by the learned Railway Claim Tribunal, Guwahati bench in original application for OA. By the same judgment, the learned tribunal has allowed refund of the punitive charge, which was the tune of rupees 2,89,28.
Lordship.
Apara, the Gogoi Learned Council has submitted that the approach of the learned tribunal is erroneous, as a wrong provision of law has been invoked. Apara has been called for the record that steps for service of the respondent be taken by registered by user process as well as by registered post proceed. Steps within 2 days.
Lordship.
List of the 6 weeks, allowing report on service and healthcare.
Lordship.
I heard take over learned council. Learned is appearing for the applicant appellant. Who appellant put the connected appeal has been filed against the instrument, which has been admitted today. That is by this present application, a prayer for stay in respect of the judgment and order date 28/4/2020 has been made. Sri Gogoi, the learned council, has submitted that there are good grounds of appeal, and if the same is not paid, what irreparable loss are you going to suffer by 2 lakhs?
Lordship. The public accept.
And the same is required to be seen in the interest of the full stop. After considering the aforesaid prayer, this court is of the opinion that a conditional stay may be granted. Full stop. Accordingly, it is directed that the impugned judgment and order dated so and so shall remain stayed subject to the condition of deposit of the amount in the registry of this court within 2 months from
Lordship.
highest. Orders. Speaking to the If the bar is agreeable, we can take up the stay matters first before the orders. There are not many matters. There are 4-5 matters, but I still find the series out. Not take much time. Yes, 44. After the NEMA. Only if the members are present, otherwise you will not operate.
My lord, item number 18, my lord,
Now we'll take up.
along with the RSA, my lord, stay petition is still, my lord.
Item number
18,
we'll
1.
take up. We'll
Yes.
look at the same matters. Only if the advocates are there. Item number 44. Yes. So what is this?
Lordship,
Is there a stay?
yes, your lordship.
And you are for procedural is for the other side.
Other side, your
Yes.
lordship.
Stay has been extended.
Stay has been extended.
You
Your
have filed
Lordship.
an objection.
No, your lordship, this can be disposed of. Actually, I filed an application for allowing me to adduce secondary evidence.
Correct.
That was allowed. And thereafter, they came to this court whereby
No, lordship. They filed two petitions. One for allowing them to adduce secondary evidence and other for a direction to the petitioners, defendant to produce the original documents. Lower court below, both the applications were allowed. And
Now, if you fail to produce the original document, there be, that is the meaning. What is the meaning of secondary evidence?
no, lordship. Kindly see, lordship.
What is yes then? Tell us what is yes. What is the meaning of secondary evidence?
Lordship,
How do
secondary.
you proceed to go for a secondary evidence?
Yes, your
Aren't you required to call for the original? File an application. Can you straight away go for a secondary evidence?
No, lordship, the petitioners respondent filed one application. Kindly see the page 108.
See, if you cannot be forced to produce the document. If you
Yes.
do not produce the document which is in your possession, he has the right to go for a procedural secondary evidence.
That is the question to be decided, whether they are pleased,
It's already been decided.
they are,
Scheduled.
lordship, they are pleased that those documents were only 4 documents. From the argument, it is only 4 documents as per their claim is in our possession. And other documents not in our possession, specific, but the court below allowed hold the documents, lordship.
Let us see the application.
Lordship,
How did they structure the application?
page 108, your lordship.
108.
Page 108, paragraph 2, your lordship. That the documents upon which relying the plaintiff has been instituted the aforesaid suit are copies made from the original by mechanical process and are shown in the paragraph 11A to 11B of the amended plan. These are the documents, lordship. Kindly see their prayer, your lordship. Next page. Therefore, in view of the facts and circumstances as cited above, for the ends of justice, your honor would be pleased to accord permission to the petitioner plaintiff to give secondary evidence relating to documents copied which are already been submitted by the plaintiff in the aforesaid suit.
Yes.
This is one application.
Yes.
And another application, lordship, kindly see page 114,
114.
lordship.
Yes.
Lordship, in this page paragraph 2 are same documents, lordship. Paragraph 2, 114, 11A to 11B, and the prayer kindly see lordship, next page.
Therefore, in view of the facts and circumstances cited above, for the ensure justice, Your Honor would be pleased to pass an order directing the defendants 1, 2, and 3 to produce the original documents before this court of the copies of the documents cited in paragraph 2 of this petition. Now, Lordship, kindly see, in one hand, they are saying that.
Where is the order?
Order, Lordship. Order starts from page 121.
Yes.
121.
Yes.
It starts. Now, Lordship, kindly see of that order, page 131.
Was 66 of Evidence Act invoked?
No.
Section 66.
No, that was not followed by the.
No, you.
It was not invoked.
Not followed, Lordship. They did not serve any notice under section 66. Without serving, without that notice, they directly filed this petition. Now, Lordship, kindly see page 131.
31.
Yes. One hand, in their two petitions, they have pleaded claim that.
This by this order at page 120, both the applications have been disposed of.
Both the applications have been disposed of. Parallelly, both the applications were allowed.
Yes. Let us see the concluding part.
Concluding that simply last portion, page 140, Lordship.
Yes.
In view of the above discussions and decisions, prayers of the plaintiff are allowed. As a whole, both petitions were allowed. That cannot be, Lordship.
This is order dated 26/7.
26/7. Now, Lordship, if your Lordship go through the, I'll point out judgment, and from there they have admitted that only four documents are in possession of the plaintiffs, petitioners, defendant number 1 and 2. Other documents not. And it is the duty of the petitioner plaintiff to prove that those documents are in possession of the plaintiffs. In that case, the court below ought to have allowed their petition. Only one, not both parallelly, Lordship. And they have not followed that section 66. They did not, Lordship.
Yes, let us reach secondary evidence.
Section 65, Lordship, secondary evidence. Cases in which secondary evidence relating to documents may be given. When the original is shown or appears to be in the possession or power of the person against whom the document is sought to be proved, or of any person out of reach of or not subject to the process of the court, or of any person legally bound to produce it, and when, this is vital, Lordship, after notice mentioned in section 66, such person does not produce it.
And there are exceptions also, 6 exceptions, where notice is not required. There are 6 exceptions where notice is not required.
Lordship. And lordship, this vital part of a person when the original is shown or appears to be in possession or power of the person against whom the document is sought to be proved. And lordship, in this case, your lordship, the petitioners did not prove that those documents are in possession of the petitioner's plaintiff. Moreover, they have admitted, lordship, kindly see, I would like to show your lordship, page 131, it starts from
131.
131. It starts from paragraph 8, your lordship. In the vociferous argument forwarded by learned counsel such and such, who has filed a written argument, has argued that the plaintiff, along with Pranay Basumatari, had been running Udalguri Indian Gas Service on partnership right from the year 2001.
We're not going to do the facts of the case.
Lordship,
Yes,
kindly
Mr.
see, next page, kindly see, lordship. They've admitted what part?
No,
The- before-
I have understood your case. We're not going to the facts.
Only four
You said
documents,
that 4 documents are in your possession.
they've admitted.
There was no,
Their argument before the lower court was all
there
there.
was no notice
Is
given
page-
to you
Yes,
under 66.
yes,
Until and unless notice is given, an application for production of secondary evidence is not met. That is your
lordship.
case.
And they did not prove that those documents are in possession of the
You are
petitioner.
admitting 4, rest they have not done anything.
No, lordship.
Yes.
Your lordship, as regard page 117, which they have proved, that's a notice under section 30 rate, which section 66 of Indian Evidence Act. 117, your lordship. For production of the document. Page 117.
117 is an objection.
Sorry.
Lordship, page 114, your lordship.
4, your lordship. That is that was registered as miss case number 606 of 2019. So first of all, I made
So
an
this is already the application made in the court.
yes, yes.
The 66 talks about a notice. The notice has to be in a prescribed form.
Your lordship, that is true, but your lordship may come to the findings of the code below. What they have starts from the order, your lordship, page 137. They have admitted, your lordship, after going through both the petitions in entirety and after hearing the learned counsel of both the parties, it is well reflected in section 65 of the Indian Evidence Act, case in which secondary evidence relating to document may be given and secondary evidence may be given of the existence, foundation and contents of a document wherein the original is shown or appears to be in the possession of power of the person against whom the document is sought to be proved, or if any person out of league or not subject to the process of the court, or of any person legally bound to produce it. And when after the same is mentioned in section 66, such person does not produce it in succeeding getting
How do
permission.
you overcome the second argument that he is in possession of only 4 and you have not proved that?
Your lordship, that the court below has reflected that one in the judgment. They have disputed they have made several contention. First, they have refused that they are not in possession. Second, they says that I am irrelevant. I have illegally taken the possession, and I am in illegal possession of those documents. Third, they are doubting that these documents are frivolous, and fourth, they are saying that these are not relevant. So these questions are to be decided by the learned trial court. Now, your lordship,
No, not on those. He, Mr. Storm is saying that out of 8 documents, he is admitting possession of 4 documents. So this, your prayer for secondary evidence may be applicable for 4. What about the rest 4 documents?
Yes, your lordship, what we have argued is that those documents were ultimately is Xerox copy where the signatures are in original. So this may be considered, if that is considered as original, I may be allowed. Otherwise, if these are not considered as secondary If these are
The
not,
documents, how can you prove a xerox copy? The signatures you can put to prove if those are original. What is xerox?
those documents, your lordship, from the, in the very plain itself, we have been stating that these documents are with them, your lordship, in their possession.
What is the suit for?
Suit for rendition of account, your lordship, and there was a partnership agreement, partnership fund. I am the plaintiff. I and the husband of the defendant was the partner of that company, your lordship, that partnership fund. Thereafter, what happened? The other partner, the husband of the defendant number one, expired, and they took possession of the partnership fund and illegally transferred the license. Thereafter, we filed the suit for suit for declaration, rendition of account, and or appointment of receiver and permanent injunction.
To support my submission, lordship, I have submitted.
We'll do one thing. We'll have this for disposal on Tuesday next. Not Tuesday. Tuesday is the holiday. On the
Your lordship,
on 17th.
your lordship, can it be on the next subsequent week?
On 22nd.
The 24th.
22nd is a Tuesday. 22nd.
24th.
24th.
Interim may be extended, lord.
As a part of matter, your lordship.
Not part of. We'll look complete. Because today is not meant for a full length hearing. How?
44, lordship.
They are so counted for the petitioner, whereas the contesting referral number 404 is represented by Sri Deep Kilal. Anyone else? Jahid is for R2. N.A. Jahid for referral number 2. Anything by you? Who are you?
IOC, lord. IOC.
Anything?
Some of the documents are in possession of IOC and they are claiming from the petitioners.
Is it in your position? No.
IOC's document, lordship. IOC's document, lordship.
Your document?
Yes, their document, lord. From the pleading that will be reflected, lord.
This matter. In this matter, notice was issued on 5/10/2021 and an interim order was passed which has been extended from time to time. Put up in the meantime from the contesting party have entered a bill. The suit being of year 2007 that this matter be listed for admission on 24th of August, on which date, an endeavor would be made to the entire
Lordship, interim may be earlier.
interim order passed earlier, then vacated.
Lordship?
Then vacated.
No, lordship, extended.
Then vacated. This you have placed.
I'll place on the next date, lordship.
Made
Yes, madam. Who is for the petition?
Oh, lordship. I'm sorry, lordship.
Bad habit. Too much of appearance for the government. Yes, you're for?
Your lordship, I am for item number 43, your lordship.
for the three.
40,
What is not
43, 45 to 49 is.
49.
Yes,
No, there is a stay order, Lordship.
have you taken steps?
Lordship, steps have been taken. Service is not complete, Lordship. In all the cases.
Culture has come.
No, LCI has not been received.
Heard MSMDB learned counsel for petitioner. Course of office notated 7/8/2023 reflect the steps for service of notice upon the private respondent has been taken by registered post as well as usual process, and service report is awaited. Full stop. The LCR has also not been received. Full stop. Para. Please after a month for service report as well as for LCR. Para. Interim order passed at date, continue to the next of
I've let you know.
TR Google and State Council is present for the case respondent. Thank you. All case, all
Same.
are free.
Lordship, 45 to 49.
Steps taken on same day,
Lordship,
same office note.
same, 7/8/23.
This will be for 45, 46, 48, 49. Separate order. Yes.
It's relating to counterclaim in a landlord-tenant case. That is the issue.
Madam, you have appeared for the respondent.
Yes, my lord, for all the respondents.
You have filed your vocal now.
Yes, my lord.
Is there is an interim order?
Yes, lordship. Interim order is there. The suit has been stayed.
Yes, today was.
In fact, Lordship, by our application, the interim order was passed, but we are affected by the interim order because of the fact that our suit is now staying. Therefore, the urgency, this is a landlord-tenant case, 2015 case.
We can fix this.
Yes, on that, therefore, what I pray, your Lordship, that is for a final disposal on 22nd, Tuesday. Your Lordship.
Suit is of which year?
2015, your Lordship.
You are for the.
I am for the plaintiff landlord.
Your ejectment suit.
Yeah.
And what is the cause of action here?
They filed a counterclaim in the landlord-tenant case.
The tenant.
Yes, we filed an application for exclusion of the counterclaim because the counterclaim in a landlord-tenant case is not meant for claiming a salami. Absolutely, and a declaration that there should not be evicted if they paid the rent. And that
is your defense, madam. The
My lord, the defense.
first part may be a.
And that's it. This is Lordship, if we allow the counterclaim in a landlord-tenant case,
No.
excluding the section 5.
Landlord-tenant case is your projection. We do not know their projection.
No,
Yes, my lord.
this admitted part.
My lord, it is not exactly landlord and tenant. In fact, these properties were sublet way back in the year 1960s, etc.
This is admission, your Lordship. I may,
And-
1 minute, please.
This is not
We
the
can
first.
have it for final disposal.
This is admission. They have deposited rent in favor of us.
Rent is.
Now, how
being
the
paid,
London come, my
definitely, but it's
sister
on the
said.
basis of salami. And in fact, my lord,
This
this
is
is not.
instructing on basis of instruction.
Yes, absolutely.
Submission is basis of
This
instruction.
is, let my sister be gone through their WS. They have deposited the rent in the rent control act.
Okay, tell us an agreed date to it.
Yes, your Lord.
Tell us.
22nd, your Lord.
My lord, some fixed PIL is there on 22nd. If it could be on 24.
24.
24th, I have a problem. Your Lord. But then 21st, your Lord.
Monday.
Difficult.
29.
My lord, I'm sorry again, my lord. I will be out of station.
25th.
Madam, you need to be.
It's very difficult.
Tell the out of station code that you are out of station in that code.
The 21st. 21st or 22nd?
My lord, I'll manage on 22nd somehow, my lord.
22nd.
22nd of August.
Wait, second we go for disposal.
Yes, Lord.
Heard to be the learned senior counsel for the petitioner assisted by Sri S. Decker. Whereas M. Agarwal,
Agarwal, madam.
P. Agarwal, learned counsel is present for the contesting respondent.
All the
Respondent.
all the
Uh, The present application has arisen from a suit of the year 2015, which according to the petitioner is an exactment suit in which our counterclaim has been filed by the defendant. There is also an interim order in this proceeding, which perhaps is benefiting none of the parties.
They may be benefited, we are not, absolutely not. My suit.
Vacate it there.
No, on the first day itself, your lordship, I am paying, but there's a tactical complication.
The court is of the opinion that the matter which is said to be a dispute between landlord and tenant is required to be heard expeditious. Sarah, in view of the same, the registry is directed to list the case for
admission.
Admission
on
22nd of August. Highly obliged.
interim order passed earlier to continue to the next.
Obliged, madam.
May I please, Lordship? Kindly, madam, to pass over for the day. My senior is not well.
Who is the senior AK Ahmed?
AK Ahmed.
Submitted with AK Ahmed conflict is unwell.
Okay, we have taken step in earlier.
Office note dated 7/8/2020. Reflects that steps have been taken, but neither ID card nor answer notices has been received back. Would compare this Dr. Raman along with press service report. Sarah, interim order passed earlier to continue to the next step. Yes, Mr. Islam,
Lordship, my lord, in this case, your lordship, the appellants, the respondent filed in title suit, your money suit, your lordship, for directing the appellant.
You're the what? Appellant is the
Respondent, yeah.
No, no,
Appellant, your lordship, appellant number 1 is the mother and.
no, you're the plaintiff for what?
I'm the defendant.
Defendant. Okay, what has happened? The suit was for?
This for your lordship.
Money suit.
Money suit, your lordship. Fact of the case is that, plaintiff case is that my husband, your lordship, during his lifetime, brought rupees 12 lakhs.
Your husband means husband of the appellant number 1.
Yes, Lord.
There are more than one appellant.
Lordship. Husband of the appellant number 1 and father of the appellant number 2, 3, and 4.
Appellant 1 is the mother.
Mother, your lordship.
And
2, 3, 4, they are the son and daughter. They are the sons, 3 sons.
who is your predecessor? Name of your predecessor?
Predecessor is Abdul Barak.
Abdul
Barak. He was
Barak.
Abdul Barak. He died on 21/5/2016.
Yes.
And the suit is filed, your lordship, money suit number 12/17, filed on 9/3/2017.
Yes. After his death.
After his death, your lordship. They said that they have in the release that my husband of the appellant warrant brought in rupees 12,60,000 and it was not recovered. Right, your lordship. Therefore, there is a general power of attorney is there and hand note to order to that. But we have contested this suit, your lordship, there. And substitution of law, your lordship, Both the cases, concurrent finding yellow, both that we have lost. And page 4, your lordship, page 3, your lordship, subsequent question of law. Page 3, your lordship. 2 and 3, your lordship, can be considered. I am going to 2, your lordship, point. Whether learned trial could act as an executing court while deciding the decree of the suit. This, your lordship. Page 43, your lordship, candidate judgment of the learned trial court.
Page
Page 43, operative portion. And 43. Bottom. The plaintiff suit is decreed of contest with cost. The plaintiff is found entitled to following reliefs. Money decreed to realize 12,60,000 from dependents at simple interest of 5% from the date of filing this suit to realization of the amount within 6 months. Next page, page 44. To sell the plot of land measuring 2 kata 10 lashes covered by Dr. So and in the event of failure dependents to repay the within money within 6 months. It is what realized. The trial court had decided the suit acted as an executive court. Cannot.
Let's see the plain.
Then your lordship page. Is your lordship page 5. Start for page 5. Then so they have lead that your lordship on the basis of that or page 5. Your lordship.
They have a specific prayer for
Prayer is there.
for plot of land.
Lordship. Page 12 is the prayer.
It's not that the trial court on its own had
Prayer is
had
there.
found a device to get this executed.
Prayer is there, but on the that prayer is there on the basis of your lordship general power of attorney. One general part is there, but after demise of the executed and your lordship, and it is the and then subsequent question of 3, your lordship, whether power of attorney, general power of attorney is substituted after demise of the executed. What is the value of that power of attorney when
Let
the
us see that part of the plaint where the entire claim is based on the GPA, general power of attorney.
page 7, your lordship. There are 3 your
Yes.
Page 3, your lordship. That subsequently the petitions of the dependent failed to pay the loan amount in favor of the plaintiff. The petitions of the dependent, namely Abdul Barak Ahmed, executed a deed of tester so 2015 in favor of the plaintiff, appointing the plaintiff as his lawful attorney in connection with plot of land so boundary so and authorized to sell and shed part of the land and to realize the loan amount after selling is the it is not there in the general power of attorney. Sale and realize them not there. General part is there, but it is not correct, your lordship. I am placing that.
And what about the hand note?
Hand note also there, your lordship.
Even if the power of attorney goes, even if we accept your submission that after demise of the executor, this power of attorney may not have any effect. What about the hand note?
The hand note also they are also denied because during his lifetime the husband the predecessor never said about that getting money and secondly and
But hand note was proved, I think. Signature was proved.
Just about that witness, some of the witnesses they had executed, they said that they are in presence of that, they were. They're-
Where city had not. There.
No, yellow, it is not meant, it is not take yellow. My placing yellow, that power cutting was there, it's a copy,
They also filed for stay.
stay alert,
Stay of money decree.
and it is that. That's-
They stay.
Otherwise, that matter and I will be infected because execution, they have filed an execution
That
case
is,
here.
can you stay money decree? What are the conditions attached? Please come.
Lot.
What are the conditions?
Is they considered matter will be infectious because execution
Not
case.
in fact, you have to deposit. Money decree. Come to 41(5). Rule 5. Where is the city?
Look, I'm sorry, I could not bring it.
You don't bring us city, you have to move a second appeal.
For putting it.
Very unfortunate.
I'm sorry, I'm sorry, I have.
Has it been put to execution?
They filed, the execution case, they have filed.
They come to order 41(5). Rule 3.
Lordship.
Sub-rule 3.
In order the execution shall be made under circumstances so and so, court making it state that substantial loss may result to the party applying for stay of the execution unless the order is made. The application has been made without unreasonable delay and that the security has been given by the applicant for the due performance of such decree or order as ultimately binding upon him.
What about the security part?
The security has been given to by the applicant for the due performance of such decree or order has been
The
ultimately
money
binding.
decree. What is the amount involved?
Amount is almost
12.6 lakh.
12 plus 60,000. You know.
Yes, 12.6 lakh. You deposit that
Amount is 2 lakhs.
2 lakh, how? 50% at least. But free as for the appellant who has preferred this bill against a judgment and decree dated 1/12/2022 passed by the learned additional district judge FTC Borpeta in money appeal number 3 of 2020, affirming the judgment and decree dated 15/3/2022 passed by the learned civil judge of Borpeta in money suit number 12 of 2017. Islam, the learned counsel has submitted that the basis of the suit, which was filed for recovery of money, is a head note and a general power of attorney. However, even before the general power of attorney executed, allegedly executed by the predecessor of the appellant, Abdul Barak, in favor of plaintiff. It is, however, contended that even prior to the institution of the suit, their predecessor Abdul Barak had passed away on 21/5/2016, and therefore the general power of attorney had ceased to exist. The the projection of the appellant is also that they were not aware of any hand note, and therefore its existence is also denied. Admit of the hearing party, the substance that the present appeal is admitted on the following substantial questions of law. One, three. Call for the record. That step be taken for service of notice upon respondent by usual process as well as by registered post steps within 2 days. List of the 6 weeks along with LTR and service report. Are you pressing the IA now? Whenever the execution starts, you
They have received notice on last date on 4/7. It was
in the IA, you
right?
That you would like to take instruction in this case and praise for the court to press the same and on any subsequent.
I will mention. I will make a mention. God bless it.
Liberty is gone.
I'm sorry, madam. Item 39, madam. It's a very urgent matter, my lord. That maybe can taken up today. It's a dusty of services already taken up.
39, we are going to the leeway.
My lord, there was the order to dispose of this matter today.
Can we dispose of now?
Short matter, my lord.
Don't make tension like this.
Obliged.
All matters are urgent.
Obliged.
What is your extreme urgency? Other councils are not sitting.
Yes, ma'am.
Did you take permission in the morning?
No, my lord. I was.
Then what is this kind of practice? Urging to the court and saying that your matter is urgent? Are we sitting idle here? We'll go sit really. Yes.
Maybe your lordship, in this matter, file caveat, my lord. May I pray, my lord, this matter may be taken up on Monday next, my lord.
You're on caveat.
Yes,
It's
that's for respondent number one, only for respondent
Copies have
number
been served upon him.
one. Yes, my lord.
Already. We'll have it on Monday.
Yes, ma'am.
Part 3, Das, PP Das, current counsel for the appellant. Whereas MSK Bhattacharya, current counsel, is present for the response number
one
on the strength of a caveat. As agreed to by the parties, list for admission. It's under 4111.
41.
Under order 41 to 11 on Monday. Let us discharge the caveat.
Yes.
Third MSK Bhattacharya, current counsel, has caused the caveat in respect of a judgment dated 6/2/23 and decree dated 30/2/23 passed by the London Court of Additional District Judge Jorhat in title of the number 1 of 2018, whereby the judgment is decreed 19/5/2018 of the London Court of Civil Judge Jorhat in title court number 9 of 2013 has been affirmed. Full stop. The caveat would be heard in the event this court proposes to pass an interim order. Caveat shall be heard. Monday. Yes. Yes, 1920. Madam,
Lordship, in this case, my senior's name is shown, but it should not be because we are not anywhere advocates for the appellant, Lordship, as per record. Mr. GP Vomik, senior, we were not engaged in that. In the corporate, Lordship.
none appears for the appellant on call. Full stop. The last two occasions also. There was no representation on behalf of the appellant. The orders passed on the last two occasions are expected here in below. Authorized Chair 2003 and 97. This court in the last order had made it clear that appropriate orders will be passed in case of further default full stop para. In view of the above, the applicants dismissed for non. This will be.
Milord.
Common order.
LCR has been received by this court, Milord. So, Milord, the hearing date may be fixed, Milord.
11 matter, MSC.
MSC appeal.
What is the appeal about?
My lord, regarding that amount, my lord,
Year for enhancement.
They are the enhancement matter,
How much was the amount granted?
92,000.
How much do you want?
my lord, 6,45,000.
That case,
My lord.
No, no,
No, no, my lord.
permanent
Accident case.
disability. But we are,
injury case,
Yes, my
not that.
no,
not
that
that.
permanent disability, but we are disputing that matter. And secondly, my STC is, it is held that STC is not at fault. There's a sumo driver who is at fault, and he was a passenger, my lord, in that case.
The liability has been settled with STC.
No, STC is 25% and sumo 70%, because STC is not at fault. my
This amount has been paid to you.
No,
Nothing has been.
nothing paid.
Why?
My lord,
We have not gone for execution.
no, my lord. My lord,
From 11, where was the accident?
my lord,
Accident? to which
Gauri
year?
Sagar.
Gorisaga.
No, where, when?
It's
My lord,
a,
2004.
From 4 to 2023, you have not got this amount. Why haven't you filed for execution? At least this amount you have got, you could have got. The entire objective is lost. 6/10/2004 was the accident.
6/10/2004, my lord. And the husband was 13/4/2011. After 7 years.
This matter we want to complete it. Today it may not be possible, but when
my lord,
In last week of August, my lord.
don't go to the last
31, my lord.
On 30 or 31.
31. 31.
31.
Part 3 pieces to consider account for the appellate, whereas the case is represented by J. Royal and Senate Council. The appeal for announcement of the award passed by MPCT Sagar is of the year 2011 and the exit is of the year 2004. This appeal requires an expeditious hearing. Expeditious proposal. However, no. Since positive time may not allow the matter to be taken up for final disposal today, as agreed to by the party. This for
31.
orders. Please not.
List for hearing, my lord.
List for hearing, my lord.
Please order list for 31st of August,
My lord.
on which the matter will be taken up for final.
My lord. Most probably.
I'm appearing for response. Matter may be fixed for hearing,
Healthcare has come
lordship.
and appears for the petitioner on appellate on call, whereas Madam, your name?
F Intel. F Intel.
MSF it does present for the sole response. Healthcare has been received. Sarah. Please for hearing. It is heard.
I'll be filing a miscellaneous application, my lord, for appointment of arbitrator, because earlier arbitrator is refused, my lord. So I'll be filing a miscase for appointment of new arbitrator.
16 matter. MS 30 and Senate Council for the petition submits that an application is required to be filed for appointment of a new arbitrator, for which he prays for and is granted 1 week time. Please approve.
Well,
May it please your lordship. Lordship, LCR has been received. Kindly the matter be fixed for hearing.
Services to complete,
Yes, lordship.
they have appeared. It is submitted on behalf. This is appeal, isn't it?
Yes, Lordship.
Appellant that the contested respondent has appeared and healthier has been received. This for hearing in its turn. Yes.
May I please your lordship? Lordship, the matter has been listed wrongly actually.
Sorry?
It was supposed to be listed on admission, but it is listed on orders. And also my senior's name is listed in respondents list. It was supposed to be in appellants, Mr. R.C. Das.
Matter has already been admitted, madam. You should check the court record, the order sheet. It has been admitted on 17/4/2017. It does not come for admission twice. Why is it listed?
It ought to have come on for in the hearing column, your
Hearing. All have appeared. Healthier has come.
Yes, your lord.
Mr. Das is for whom? Appellant.
Appellant.
Healthier has been received and the matter is right for hearing. This
Yeah.
for hearing in its turn. Basically to reflect the name of the R.C. Das as learned counsel for the appellant.
Your lordship, kindly fix a short date for listing the matter again.
We come for hearing 17 matter.
Okay.
In person. Understood. Actually, it's just 2 meters. I here take away. There is continuous default on the part of the petitioner who appears in person. Full stop. Such default is still from from the orders dated 29/1/2021, 21/11/2022, 24/2/2023, and 14/6/2023. However, since there is no representation even from the respondent, matter is adjourned to be listed after 2 weeks. This court is, however, of the view that the contempt petition being one which is essentially between the court and LS contemptor, on the next date fixed, after hearing the respondent. On the next date fixed, if the petitioner in person is again absent, this court will pass appropriate orders after hearing respondent. non-habeas position. Appellant on call. Thereafter, on the last occasion also, that is 25, 20, none had appeared for the apparent. In the interest of justice, list after 2 weeks.
Lord, may it please your lordship. Lord,
Therefore,
I'm for the applicant, my lord, I is for condonation and restoration, my lord. 113 days delay in filing restoration, my lord. The ground taken, my lord, is
that notices have gone.
yes, my lord, they have appeared, they have.
Who the PS?
Yes, sir.
Yes, what do you say?
Your Honor.
Have you filed objection? Have you filed objection?
Yes, Your Honor, we filed objection.
You filed objection. What have you said in your objection?
Your Honor, it's not a good ground, Your Honor.
Not a good ground.
They are taking a claim that the senior advocate could not appear. But that is not the case. They have 5 advocates under him. So that cannot be a good ground, Your Honor.
Where are your grounds?
My lord, in IA 4246.
Page
My lord, page 3. My lord, even I admit, my lord, grounds are not so concrete, but my lord, even we are subsequently engaged in this matter. And senior advocate, he passed away, and that is one of the reasons why the other counsel.
What was the matter about?
My lord, the matter actually is there was a probate application which was filed after 25 years of delay. my lord.
That's demise.
Yes, no, my lord, the original probate case which was filed in the learned court below was after 25 years.
25 years of the demise.
After demise. As the practice was there, the judgment of this honorable court, a condonation application was to be filed. That condonation application was only dismissed, my lord. Against that, this instant case, test case was filed. During that pendency, my lord, the engaged counsel did not appear, and the matter was dismissed for non-prosecution, my lord. Then
your habitual your neglect is apparent.
No, my lord,
even there you have come before the court after 24 years.
No, my lord, that is a good ground, my lord. After 24 years, we had properly explained. Knowledge came because my father's friend had the original will with him. We were not aware about the will. He told us after.
Then suddenly, from where did it erupt?
After, when there was a suit also filed by one of the brothers. At that point of time,
for 25 years, what was he doing with the will? Your father's friend of your father.
That friend also did not, my lord. His son, after discovering into the locker, he got to know that there is a will, and he, with a humble thing, my lord, he came. There is merits in that test case, my lord, that I can submit. But
yes, Mr. Das, restoration.
Yes, my lord. The ground first, lordship.
No,
the ground taken by the.
He has admitted that the grounds are not very strong grounds, but somebody has passed away. Who was the counsel also?
Senior counsel, my lord, A.S. Bhattacharjee.
Okay, he passed away.
Yeah. And
Another co-counsel
did not appear.
engaged in this case.
Who was with him? Who had the counsel? Was it an engaged case or a chamber case?
No, chamber case.
Then
My lord, even this application was not filed by us as a counsel, my lord. We were also engaged subsequently.
Mrs. J. Gogoi, Mr. U. Bhattacharjee, Miss S. Roy, Mr. D. Deka.
probably all his chamber juniors.
Yes.
Not be proper. You know the practice. The senior passes a chamber bills are
I file objection in this regard. My lord.
heard. What Bhatra?
A. Bhatra.
A. Bhatra. Counsel for the applicant who by means of this application has prayed for condonation of delay of 130 days.
113 minutes.
113 days in filing the application under 41 order 41 rule 19
Yes, my lord.
of the CPC for restoration of the appeal which was dismissed for default on 15/7/2009.
Thank you.
The learned counsel has submitted that the earlier senior counsel who was handling the matter could not appear due to some ailment, and thereafter had also passed away. He accordingly submits that the delay may be controlled and the appeal be restored to 5. Put the parent 3. Thus, the Senate counsel for the sole opposite party.
Yes, my lord. Only one.
For the opposite party, however, submit that there were other counsel along with the senior counsel, and ailment of one counsel cannot be the reason for non-appearance of the other counsel. He has referred to. He has also submitted that an objection has been filed to the application for condemnation of the offense. After considering the facts and circumstances and also taking into account the settled law holding the field of delay of adjudicating a delay condemnation petition, wherein a pragmatic and justice-oriented approach is necessary, the delay of 113 days in filing the application for restoration is controlled and controlled. I accordingly send both of. Restoration will pass order same day. Today, sir. Heard 3A Bhatra, Learned Counsel for the applicant who has filed this application under order 41 rule 19, read with section 151 of the CPC for restoration of intestate case number 5 of 2017, which was dismissed for non-prosecution on 15/7/2018. The delay in filing this application has been controlled by this court today in IA number 4246/2009. Also heard the AJ Das Learned Counsel for the sole opposite party. Sri Bhatra, the Learned Counsel for the applicant, by referring to the amendment made in paragraph 5 of the petition, has submitted that there are good grounds for restoration. Also, thus, the fight objection here, no.
Yes.
Here also.
Yes.
Thus, the Learned Counsel for the opposite party, however, has resisted the prayer and has submitted that objections have also been filed. After hearing the party and considering the facts and circumstances of the case and the nature of original litigation of the present application for restoration of appeal is allowed. According directed that intestate case number 5 of 2007 is restored to 5. Allowed, and the order date order dated 15/7/2009 is revoked. Thereafter, I according to that.
Lord, our names may be reflected
In the main is to right in view of the order passed today, that is in IN number 20, whereby this case has been restored to fight, registry may release this case for orders after 2 weeks. Put up the names of P.A. Bhatra
And BD document.
and his colleagues appearing for the appellant may be reflected in the call.
Much of.
Rest will give the
Item 34 may be listed for admission next week, madam. May be listed for admission, not for order, madam.
34.
34, madam.
Maybe some service report.
My lord, five persons already served, my lord.
Appeared.
Appeared.
Lordship, in item number 35, there is an interim injunction which needs to be extended.
35.
35 in IA 351 of 22.
I positive. 2 weeks. Interim order. Any more case where interim order?
Wait, please, Lordship. Item number 29, as per order date 5/8/23, RDB is present today. So may kindly fix the matter for hearing. LCR has been received.
No, without application of mine, we cannot. Yes. Any orders where, any matters where interim order needs to be extended?
Lordship, item number 36. Next,
Next date he'll give. Matters where interim order needs to be extended, any matter.
Item 39 matter kindly taken up tomorrow.
Not for. See what it.
Item 34.